they paid on behalf of state on 8.
Okay, সোমবাবুটা করে দেবেন, হ্যাঁ? To be mentioned Monday.
Monday. I'm grateful to you.
Yes.
My lord, for correction, my lordship delivered the judgment on 9th, my lord. My lord,
Okay, to be mentioned what correction?
this your lordship directed the inquiry by the UGC, but my lord, I was recruited under the AICT regulation, and the institute is also recognized by the AICT. So instead of UGC, it should be AICT, my lord.
Oh, to be mentioned.
Grateful, my lord.
Give notice to a other side. Today is not mentioning day.
Because
Okay, give it. Yes, call the list.
Item number 1,
I appear for the respondent bank, your lordship.
Yes. Yes.
My lord, my opposition may be kept on record. I have served them, they have served me with a reply. This is my opposition.
Affidavit exchange by the parties are taken on record.
Petitioners, there are 4 petitioners. That is 4 companies. Directors are same. They have been running, my lord, 4 separate cold storage. Supplementary.
Supplementary affidavit. Have you got the copy?
Yes, your lordship, I have.
Oh,
What happened, my lord?
I mean, affidavit exchange by the parties as well as the supplementary affidavit filed on behalf of the petitioner are taken on record.
But all together, petitioners have been enjoying credit facilities of the UAI from United Bank of India, but presently as well as Punjab National Bank. In the year 2013, petitioner somehow has been convinced by the bank to purchase a closed NPA cold storage, my lord, through bank sale, with the assurance that bank will extend the credit facilities to the petitioners. My lord. Petitioner ran the rice mill for 2 years, and my lord, make it viable. All loans have been paid. Then they have again been assured that if they purchase another 3 cold storage, the credit facilities will be increased. Nothing has been done, but petitioners paid all the amount. There was not a single instance of any default, nothing. Then in the meantime, your lordship, 2016 demonetization, all these MSME enterprises, micro and small, medium enterprises, all the 4 companies faced huge financial loss, including the other, all over India, all the enterprises. Then a scheme has been came into the picture by the Reserve Bank of India. If you kindly turn to page 54, the circular issued by the Reserve Bank of India at page 54. One-time loan restructure policy is dated January 1st, 2019, issued by the Reserve Bank of India. Only for micro, small, and medium enterprises. All the 4 companies are registered under micro, small, and medium enterprise. There is no dispute. Certificate I have annexed, if not to show. But I am reading first paragraph. Please refer to the circular number so and so, dated February 7, 2018, and number so and so, dated June 16, 2018. In this regard, with a view to facilitate meaningful restructuring of MSME accounts as detailed in the Micro, Small, and Medium Enterprise Development Act 2006, that have become state, it has been decided to permit a one-time restructuring existing loans to MSMEs classified as standard without downgrading the asset classification, subject to the following condition. My lord, kindly turn the page. Next page, at page 55, kindly turn to paragraph 2. Banks,
Yes.
your lordship, at page 55.
Yes.
Banks and NBFCs declared to adopting this scheme shall put in place a board-approved policy of restructuring of MSME adverse under the instruction with a month from the date of circular. The policy shall entirely include framework, so and so. Then kindly turn the page, page 57.
Yes.
Page 57 is the same circular by the United Bank of India. They have adopted it issued on 18 January 2019. Kindly see, my lord, the top subject, sub restructuring of advance accounts under micro, small, and so and so. Then second paragraph. The proposed mechanism of restructuring of advance shall provide for the valid MSME opportunity to sustain in the long run and shall facilitate the holding of accounts development SMA 2 for so and so. If last line you will also kindly see it is not a valid defaulter so and so. So I am not a valid defaulter, so there is no question about the same. Then kindly my lord come.
You are not,
I am not defaulter.
Oh.
Admitted position. Defaulter cannot apply for that condition is there. Now
okay.
kindly come to my lord page 59. One of the condition was in the bottom portion, if you want to kindly see, for exposure above rupees 2 crore. Well, our demand is also more than 10 crore. Techno-economic viability study report to be obtained for exposure of rupees 10 crore and above. This is one of the condition. We are falling under the same said scheme. Then kindly turn the page. Well, this is 24 January 2019, issued by the United Bank of India. For implementation of the scheme framed by the Reserve Bank of India, implementation of the restructuring policy of advance to micro, small, so and so, the policy of so and so 25 crore, need not go through the entire thing. You will also kindly turn to page 62.
Yes.
Kindly bottom portion A, for exposures above rupees 10 crore, techno-economic viability study report to be obtained for exposure of rupees 10 crore and above. Now you will also kindly see that cold storage has been also incorporated by the memo dated 22nd February 2019, which will appear from page 63. You will also kindly turn to page 63. This is a circular issued by the United Bank of India. Well, kindly see the subject, restructuring of unit train to agricultural food products, cold storage. And kindly turn the third paragraph. Considering the challenged time the agriculture sector to going through Indian Finance Association white memo dated so and so directed that the restructuring scheme of Reserve Bank of India by circular dated so and so I have placed before lordship joint will be adopted to unless related to the agriculture and food and cold storage. So cold storage also coming under the purview of the scheme framed by the Reserve Bank of India. Then you also kindly turn the page. The Association of the Cold Storage made a detailed representation intimating the United Bank of India for providing such restructuring policy as framed by the Reserve Bank of India. This is dated 16 July 2019 on behalf of all their members. To the Chairman, SLBC Subcommittee for Agriculture and Allied Activities. Then kindly turn to page 70. The individual application submitted by my client, which will appear from page 70. This is all cold storage jointly signing this representation has been made. Page 72. The signature of all the cold storage are there. You will also kindly turn the page 74. 4 companies have applied for serial number page 74, 17, 18, 19, and 20. These are the petitioners. At page 74. They jointly applied for, signed by all the cold storage, including all 4 petitioners. Then also kindly turn to page 79, the individual application.
Yes.
Page 79, one of the petitioner number 4. Then page 86. The details have been submitted. Kindly see all the documents.
Yes.
86, kindly see serial number 7. TV report and CMA data as on so and so unsigned. This has also been submitted, which is required in respect of loan, which will be above 10 crore or 10 crore. Then next page, another company, petition number 1. All 4 companies separately applied for with all documents, valid documents. Then kindly turn to page 103.
Yes.
But this is the minutes of the state level banking committee held on, kindly see 5th December 2019, and the minutes has been issued as minutes proceedings 7th December 2010. Kindly see agenda serial number 2, stress in cold storage sector and restructuring thereof. This was one of the issues. restructuring of the cold storage, one-time cold storage, one-time restructure. Then I'll kindly read the first paragraph. The meeting held on so was convened to finalize the ceiling sectors of the potato bank with financial pertaining to the current assessment rule on so Director Agriculture Department so extract have been given, then kindly turn the page, next page. এটা পড়া যাচ্ছে না। Kindly come page 109. I'm handing over a copy. Otherwise, not readable. Paragraph 2. 104. Sorry, 4. 104, my lord. Second paragraph. আপনারা পড়তে পারছেন? May I read, my lord? Page 104, second paragraph.
Yes,
But this is the part of the minutes
based on above consideration.
during the discussion.
Yes, during the discussion. Yes,
During the discussion,
yes,
during the discussion, representatives of the Cold Storage Owners Association informed about the financial stress faced by them on account of unfavorable market condition in the past couple of years and requested the banks to consider their request for restructuring of the loans. The advice of Information of Finance has also opened that the request has been made by the store owners for the
Store
past
owners.
years and needs a considered view on the part of the banks. Then I'm reading, my lord. It was unanimously accepted that the
sector is facing stress for the last 3 years
sector
due
is
to market dynamics. Yes,
last 3 years.
last 3 years due to my market dynamic, the prevailing price at the present point of time is favorable enough
Point.
for the producer to take release of
Your lordship has a type copy.
but the price adjustment happened too late instead of
Adjustment happened to the
already past of adverse market
No, only
pressure
after
and
the cold storage
incurred warranty unwanted loss.
These are the vital points. Kindly read, my lord, the next paragraph. The convener of the SLBC stated that the restructuring of advance for stressed accounts can be undertaken under the provisions of the RBI circular dated so and so, which I have placed before your lordship, as applicable for states for standard accounts registered under NMSA Act so and so. Act. Well, this is page 105A.
105, yes.
The second paragraph I am reading after third line. The member banks are to take a call on this matter individually, and whenever required, bankers are taking up the matter with the regular for necessary clarification. Bankers also shared the opinion that based on the merit of the proposal so for restructuring, they will dispose of the same on priority basis. RBI has also informed that the decisions taken by the central officer RBI is not to be followed in the context of the ambit of the so and so. But all these things has been happened, but so far our application is concerned, no steps have been taken. The first document I have placed before your lordship, the Central Reserve Bank of India circular, that has been quoted in the second paragraph. This is 1st January 2019, which will appear from my writ petition at page, my lord. That's the first document I have placed before your lordship. Page 46, 54, my lord. That I have shown to your lordship, 1st January 2019.
Page 50.
54. That has been quoted at page 105.
Yeah, yes.
So they are following this and there is no dispute. The guideline which has been framed for restructuring by the Reserve Bank of India has been approved by the UBI. All application has been submitted. No steps have been taken, my lord. They will also kindly see the attendance in the said meeting, page 106, serial number 15. One of the members, serial number 15, is the representative of the all petitioners. His signature is appearing at serial number 15 of page 106. Now you will also kindly turn to page 1110. 1110. 1110. 110. Sorry,
Okay.
110.
Yes.
110.
Yes.
Further representation has been submitted on 11th May 2020. Kindly see, my lord. addressing to the Punjab National Bank. It has been converted in the Punjab National Bank. So we have made representation to the Punjab National Bank also. It will also kindly see the bottom portion, your K-bill. Next page, page 111, all the 4 writ petitioners. These are the writ petitioners before your lordship today. 1, 2, 3, 4. All have submitted their separate representation and jointly also. Then your lordship kindly turn to page 127 straight away. No response, no reply, nothing. Your lordship kindly turn to page 127.
127.
The signatories of that document, all the writ petitioner I want to show before your lordship at page 127.
Yes.
Then kindly next page. In the meantime, my lord, COVID has spread out in our country and the circular has been issued by the Reserve Bank of India. Your lordship kindly turn 27th March 2020. Your lordship knows possibly these are the circulars to facilitate all the units. So far the COVID stress is concerned, kindly take note of, my lord, all addressed to the all commercial banks, including small finance banks, local banks, so and so, all primary urban banks. Then, my lord, Madam, dear sir, COVID-19 regulatory package. It's a date, my lord, 27th of March 2020.
Hmm.
I have submitted before lordship all applications with all documents, no steps, nothing has been done. So far the structure is concerned. In the meantime, COVID came into picture and central government issued this circular. If you lordship kindly take note of. Please refer to the statement of development and regulatory policy released on so and so, where their regulatory measures were announced in mitigate the burden of based services brought about the disruption of account of COVID-19 pandemic and to ensure so and so. Rescheduling of payments, loan terms, so and so, aspect of all the so and so, including agricultural, shall and crop loans, all commercial banks, including so and so, cooperative banks, all in financial services are permitted to grant a moratorium of 3 months on payment of all installments failing due to between March 2020 and May 31st. But these are the pure. Relaxation has been given to all. Then turn the page. It starts from March 27 for 3 months. It means, my lord, June. Then kindly turn the page, my lord, page 129. Classification as special minimum amount of so and so NPA, non-performing asset. Since the moratorium so and so of the drawing power of being provided, especially to enable the borrowers to continue facilitate from COVID-19, the same will not be treated as concession of changes in terms and conditions of agreement due to financial difficulty of the borrowers under paragraph 2 of the annexure to Reserve Bank of India, so and so, so and so. The asset classification of term loans which are granted relief as per paragraph 2 shall be determined on the basis of the revised due dates and so and so. Similarly, working capital, which has been recorded. Then I will kindly come to page 131. This is Reserve Bank of India. Next circular, so far the COVID is concerned, time has been extended. This is very important, my lord. May 2022. Kindly read, my lord, second paragraph. Referring facility. The Small Industries Development Bank of India plays an important role in meeting the long-term funding requirements of small industries. In view of the lightening of the financial conditions in the wave of COVID-19 pandemic and difficulties in raising resources from the market, the RBI had announced a special finance facility on so and so. Advances under this facility were provided at the RBI's policy report date of the time of the for period of 90 days. Then another 90 days, while you can take note of. In order to provide greater flexibility of the SBI in the operation, it has been decided to roll over the facility end of 90 days for another period of 90 days. So that from 22nd May, another 90 days has been extended. There will be no NPA declaration to any MSA unit or other units also. Then I will kindly come to page 124, 134. I'm sorry, my lord, 133. Kindly turn to page 133. 133.
Yes.
Paragraph 6. Your lordship need not
Yes, yes.
Entire document, entire paragraph, kindly come to the last three lines. Sentence starts in view of the extension. Have you
Hmm.
also got that?
Yes.
In view of the extension of the lockdown and curtailing disruption on the account of COVID-19, it has been decided to permit lending institution to extend the moratorium on term loan installments by another 3 months, that is with effect from June 2022. Next page is also one paragraph is important. Kindly turn to page 134, last paragraph. In respect of all accounts for which lending institution decides to grant moratorium deferment and which were standard as March so and so, 90 days NPA will be extended, moratorium so and so. So same thing has been recorded. Need not go through all these things. You'll also kindly come to page 137. But this 137 page is not legible, my lord. I'm handing over a copy to my learned friend also.
No, it can be
Page 137. Readable?
137.
Absolutely not readable.
Yes.
2 pages have been typed or xerox in 1 page. You'll also kindly
137, yes. 13 to notice.
Fine.
13 to notice in respect of borrower,
so kindly see that date.
4 borrowers, no 3.
No, I'm
They mentioned the name of 3 companies or all 4.
kindly come the table when it has been declared NPA. It has been published in a separate date. Kindly turn to the table. Right hand side, small box, middle portion.
Yes.
Date of NPA. Have you also got?
Yes, yes.
22nd of June 2020. The first petitioner, 1, 2, 3 out of 4, 3.
Hmm.
In the moratorium period, when the Reserve Bank has decided not to declare any NPA, this has been declared by all 3 rice mills, my lord. Date of NPA, kindly take note once again, 22nd of June 2020. Date of issuance of NPA. All the 3 rice mills. And you see the next one, 22nd June, then again, my lord, 22nd June. I have shown to your lordship the Central Reserve Bank of India circular, which subsequently extended and which was in possession in the meantime, it has been declared. Now, your lordship, kindly take back the repetition. And categorically, I have stated, my lord, paragraph, my lord, paragraph 30 at page 20, no 32 notice has ever been given to me. Before declaration of NPA, within the period when central government has relaxed it, without issuing any 32 notice, straight to NPA. And so far the restructuring I have already submitted, in spite of submission of all documents, no reply even. Others have been granted. Almost all the association members have been given. So far I am concerned, my lord, that has not been extended to me. On the contrary, my lord, NPA has been declared. Now you will also kindly turn to just a minute.
When you submitted a proposal for restructuring,
First of all,
when can you tell the date?
date. Page 70. That's 7 September 2019.
That is
First.
prior to declaration of NPA.
Yes. There is a dispute of, they are not disputing also. First, my lord, restructuring policy came into picture. Immediately within time, we have submitted along with all documents. No steps have been taken. Association made representations. Other cold storage have been extended that benefit. In the meantime, central government COVID circular not to declare any NPA. Within that period, instead of restructuring, NPA has been declared all 3 units out of 4. Now, your lordship, kindly come to page 170.
So they have not published any notice or served any notice,
Under section 13.2.
even 13.4.
Well, there was an order of stay. That is why we couldn't publish
Order of
order
stay.
of
The
stay.
petition by
Yeah, by the division.
Sir, I-
I'll be placing, my lord.
Oh.
Let him complete.
attend to notice in respect of the NPA.
My lord, let my learned senior complete, my
Yes,
lord. I'll be addressing.
Okay,
But kindly come to my lord, page 173.
170.
Fine.
Yes,
Thereafter, my lord, with numbers of representation we have annexed, which will appear from page 139 onwards. For restructuring, time and again, page 149 also, 4 separate companies. Time and again, we have submitted our representations. Then kindly come to my lord, page my lord, 165.
165.
And it's P8.
Yes,
Quotation of destruction addressed to my client, 3 units. Kindly come to my lord, second paragraph. As per proposal, other than a loan is 15 years, but as per circular, it came to so and so, payment so and so. Kindly take note of. NPA has been declared. Now they are taking the restructure policy, addressing to my client. On the one hand, my units have been declared NPA. Total non-application of mine. Now they have taken out my application for restructuring. This is dated, my lord, 30th January 2021. Then page 167, I have given my reply.
157.
167, my reply to that letter. Repeatedly, I made our representations, praying for restructuring and withdrawal of the NPA. It is very surprising, a unit has been declared my lord NPA, and thereafter they have taken the cause of my lord restructuring.
Hmm.
These are my all representations. Demand justice also. To
That is the dispute. That is the dispute.
That's the case. Now, what happened, my lord, initially when we moved this writ petition, the coordinate bench refused to grant an interim order, which compelled us to file an appeal, and the appeal court passed an interim order of stay. So kindly take up. Need not go through the entire order. Second page, kindly read one paragraph. Till the writ petition is decided, the respondent bank is restrained from taking any further action as against the appellants under the Supervisory Act. These are the still it is enjoying. We are enjoying this interim order. So, well, 2 points I have canvassed before your lordship. The first point is that sub-bank restructuring policy, despite submission of representation application with all valid documents, that has not been considered and only considered after declaration of NPA. The second point we have urged before, I have urged before your lordship, that in COVID period there is a specific circular not to declare NPA to any units. All have enjoyed. When these circulars was in force, they have declared all my 3 units out of 4 NPA. And surprising enough, after declaration of NPA, they have taken out my application for restructuring. Now, my lord, this point, so far this case is concerned, one judgment I am relying, latest judgment, 2024,
Pronits.
2024, volume 10, Supreme Court cases.
Pronits.
Well, hold it. I'm get to lordship. May I read or needless? Paragraph 21, 22, since your lordship is conversant with this judgment. 23 also. 20 to 23.
I have already opened in
I am not. The first issue is concerned.
which paragraph?
My lord. My relying on paragraph 20, 21, 22, and 23. The identical issue.
Yes.
And may I read or
Yes.
20, 21, 22, and 23? Binding effect of the Reserve Bank circular.
Yes.
The next judgment I'm relying on, this is reported 2009 volume 8 Supreme Court cases, page 257. Paragraph 15, 18, 32 and 42. 15,
32
18,
and 34.
15, 18, 32 and 42.
Yes.
15, 18, 32 and 42. The same issue, my lord, whether the RBI guideline is mandatory effect or not, whether it is binding upon all the financial institution. Supreme Court with no uncertain term says it is mandatory and binding. They have to follow it.
Direction of the Reserve Bank is binding upon all the banks.
All the
Yes,
financial
it is binding on it.
Fine.
Pronits also said so.
same.
Ah.
And this is a single bench judgment of our High Court Justice Motion Court. Paragraph, my lord, 18, 20 and 24. COVID circular. The identical issue, entry has been declared without following the COVID circular of the central government. Our High Court cost and set aside the same. Kindly turn to my lord, paragraph 18 first.
Yes.
The fact that the petition number 1 was eligible for restructuring both under so-and-so would appear from the clause so-and-so, and further that the petition number 1's account so as standard assets as on so-and-so. Like us, my lord, it is significant that the loan accounts of the first petitioner were declared NPA only on 29th November 2021. Second, the respondent bank's failure to consider the petitioner's application is contradictory to the purpose of for which RF was structured and conceptually by the RBI, namely for one, the measure of so-and-so. Third, the petition number 1 was within the time limit contemplated under clause so-and-so. Then you will also kindly come to next paragraph, paragraph 20. The facts have been stated in paragraph 18, entirely covered our case. Paragraph 20, I am reading. It is also without dispute that the circular have statutory force having been issued by the Reserve Bank of India under the Reserve Bank of India Act 1934. These circulars are binding on the constituted bank and banks and under the statutory obligation to comply with the mandate of the circular. This was recognized in Central so-and-so case, where the Supreme Court held that the power conferred by Section so-and-so of the Banking Regulation Act is coupled with the duty of the Act, and further that the Reserve Bank of India as the prime banking institution in the country is entrusted with the supervisory role of so-and-so. Then paragraph 22. 24. Need not go through 24 to come to paragraph 24. Cost and set aside. Squarely cover our case. WPS so-and-so is accordingly allowed by declaration that the impugned notice dated so-and-so is the my lord NPA notice is liable to be, in our case, it has been issued on June, is liable to be quashed, stating that respondent from so-and-so, it has been quashed and set aside. And direction has been given for restructuring. But these are my case. I need not make any further submission. 2 circulars I have relied on. Both has been not been complied with by the concerned bank at present manner, Punjab National Bank. Circular date 5th November 2019. Long it has been.
Circular date 5th November.
2000. Restructuring proposal. Sorry, restructuring proposal. First restructuring proposal.
5th November 2019.
5th November 2009.
5th November 2009.
Yeah, I hand over a short list of dates, my lord.
Yes. Yes, madam.
These are my points.
But
Okay.
the very first point that was taken is that the NPA is bad. They have sought for restructuring, and Malad, the restructuring was not given, and the bank was silent. Malad, this statement is completely wrong. That will be borne out from the annexures that they have annexed themselves, and also Malad from the documents which I have gathered from the bank. Malad, on 18th of January 20, on 4th of January 2020, Malad, it was first informed to the petitioners that why the restructuring could not be given. My lord, there was a default of more than 12 crores. Why the restructuring could not be given?
Date.
Lordship, 4/1/2020. 4th of January 2020, it was communicated, my lord, to the petitioner, that is Riddhi Siddhi Cold Storage, on 6/1/2020. My lord, the company was under my lord, kindly, my lord, have my lord. My lord, this is not annexed with my affidavit in opposition, as back then, my lord, I did not get the proper instructions from the bank. If your lordship wants, my lord, I can give it on affidavit if your lordship feels so, or my lord, I can hand it over.
Reply has been
My lord, this is the admitted document, your lordship. They have received it. Your lordship, this is the document that on 6/1/2020. My lord, I'll read it for your lordship. That in response to your proposal on restructuring with enhancement of limit, it has not been considered by the competent authority and is declined. Please ignore our earlier communication made with you. It proves, my lord, earlier there was a communication. I'll also be showing from their document also. In relation to proposal of restructuring. Further, we request you to kindly deposit the overdue amount in loan accounts as mentioned hereunder and submit a fresh proposal for availment of seasonal cash credit limit of 2020. Anyway,
I could have understood had there been any pleading, at least in the opposition.
my lord, in the
Yeah,
opposition,
after
there are pleadings. I will be showing. In the
Huh?
opposition, there are pleadings that there has been communication, my lord, it was declined. That I'll be showing from my opposition. My lord, now,
Okay. So,
my lord,
otherwise,
my lord, first, my lord, I will draw your lordship's attention to their document annexed to the writ petition at page number, my lord, 98.
no, you just satisfy one by one that you, affidavit in opposition, you stated
Yes.
that by a notice dated 6 January 2022, you stated that
I did
your
not state that in my opposition.
no, you stated you informed them of the fact that your proposal for restructuring has been turned down.
Yes, yes, your lordship.
You
That,
just show.
yes, your lordship. That I have done, my lord, in my affidavit in opposition. My lord, my paragraph number 8 to that effect.
Paragraph number 8.
Roman 8, it is your lordship.
Yes. Paragraph
That-
number 8 means in reply to such and such.
No, your lordship. Roman 8. Roman 8.
Roman 8.
Page number 5,
Oh.
paragraph number 8. Mala, 2 lines are there.
I'm coming. Roman 8, 7, 8.
Not find any date.
Mala, there is. I will be placing. My lord, it is stated in paragraph number 8, if I may read it, your lordship, that the restructuring proposal submitted by the writ petitioners were declined. Thereafter, writ petitioner number 5, representing the writ petitioners number 1 to 4, submitted a representation on 1/5/2020. My lord, I have stated that earlier it was declined. Thereafter, they have given on 11/5/2020. It was declined on, my lord, 6th of January 2020. Thereafter, they have given another proposal. My lord, they have stated that all through the bank kept silent. My lord, I'll show from their letters itself where they have admitted that yes, the bank has communicated to them. At last, my lord, they have prayed for time to revisit it. I have stated in
Madam,
opposition
Madam,
category.
question is they are disputing regarding the acceptance of this document. This document is not part of record.
I can bring it on record if your
Only
lordship say.
on one condition, it can be taken and looked into by the court if you refer this document to in any part of your pleading.
Lordship, they have given a
So
supplementary
you
affidavit.
stated that on 6 January 2022, on that date, you gave them a letter
Lordship,
informing that your proposal has been turned down.
lordship,
6 January 2022.
lordship.
If it is referred to in the pleading,
I-
then court can accept it,
I bow
can
down.
consider. Otherwise, it would be out of
Lordship, I
pleading
bow
or
down.
court
Lordship,
cannot go
Lordship.
if they object.
Lordship, I bow down. Lordship, being appearing for a bank, my lord, I did not get the instruction as on that time, my lord. I have this. I did not get the opportunity to annex in my affidavit in opposition. If a liberty could be given to me, my lord, I'll give all this, my lord, on records. That there were even after.
Yeah, record, where is your pleadings?
Well, my pleading is there that it was rejected prior to 11/5/2020.
They are objecting that it is not in the pleadings.
My lord,
Unless you know very well better than me, unless anything in the pleading, any document is referred to, whether it can be accepted or it can be considered.
Lordship, kindly sees, my lord, the date of my opposition. My lord, it was 17th of August 2020. Back then, the COVID period was also there, my lord. I also could not get the proper instruction. I have served them that, and that is why they have given.
Okay, and another way out I can give you, if your subsequent correspondence, you can mention that this letter was referred to.
This letter was not referred to, but
Otherwise, it would be treated as implanted.
Lordship, they
You show any of the party?
Lordship, they have referred.
Because of the fact there was a series of correspondence in between you and the petitioner.
Lordship,
So at any point of time, in any correspondence, you refer to the letter dated 6/1/2020.
my lord, I'll be very candid to you.
Matter ends.
Lordship, I'll be very candid to you, Lordship. The 6/1/2020, the date is not mentioned, but it is mentioned in their
So
letter.
don't refer this, you will take it back.
Well, this is a part, this has to be
If
a
they
part of
don't
record, your
object-
Lordship.
I
Lordship, they cannot deny they have not received it because I'll be showing from my
so
record.
they are received endorsement, so they are
Lordship, I'll
any-
issue- I'll bring it. Give me 1 day's time, my lord, I'll bring because it has been served upon them. They cannot deny this, my lord. Furthermore, in their letters itself, my lord,
they
these
are denying.
my lord, in their letters itself, my lord, if may I show, my lord, they have referred the several correspondence have been made with the bank, and today they are making this statement. The bank has not made any communication. My lord, kindly seize their letter, your lordship.
Yes.
May I just highlight one line? Will also kindly see what my learned friend wants to show before your lordship.
My lord, what I
Barak-
want to show, my lord, I'll be showing, my lord. That liberty, my lord, I will crave leave.
Oh,
my lord,
go,
what
go.
I'll be showing.
Yes. So
If lordship kindly comes to, my lord, page number 98 once of their writ petition.
yes.
My lord, they have written in response to our caption review come restructuring and enhancement proposal. My lord, why the review come restructuring? Because earlier it was declined. We have received many communication from the regional office and the branch of our bank has cited under reference. They are themselves admitting that they have received many communications from the regional office. Very tactically, nothing has been annexed with the writ petition other than the one of 2021. Lordship, now kindly cease to page number 93 also. Lordship, in page number 93 also, they have stated in response to our caption review come restructuring and enhancement proposal, we have received many communication from the regional office and the branch of our bank as cited under reference. Well, they have received. Now, if your lordship kindly comes to their last, where they have prayed for revisiting, Malad, may kindly come to page number 168.
ওইটা দিন তো একটু কাগজটা দিন তো হ্যাঁ দেখে রেখে দিই আমি ওই যে রেফার করেছিল ইয়েস থাক হ্যাঁ থাক
Malad, at page number 168, they are stating at point number 9.
Yes.
8/2/2021, we visited your kind self and brought the contents of your kind notice, and you kindly advised us to revisit on such and such on 15/2/2021 for discussion. Meanwhile, that time NPA was declared. Declared.
After declaration of
After declared, but they have referred. Why they have prayed for time? See, page number, paragraph number 12. Sir, this is well known. That preparing a 4 number of revised proposals requires some reasonable time. Especially the TEV reports are very difficult to get within 5 to 7 weeks. However, your kind information, we would like to mention that we have taken up the process instantly, having our discussion on 19/2/2020. 19/2/2020, there were discussions with the bank. Prior to that, it was declined, Malad. I have placed the letter. I was handicapped at that point of time, Malad. I couldn't bring. Malad, it was rejected. They have given their proposal. The only contention of the bank was you pay your amount of 12 crores and something. Thereafter, we will be restructuring it. Since you are at default, the only clause was there if a unit is at default, Malad, restructuring could not be given. There was default. That is the reason the restructuring could not be given. At last, they prayed for time. Malad, after praying for time, Malad, after getting the 13-2 notice, they have come before this honorable court for a stay of the surfacey actions. Second thing, what has happened, Your Lordship, we have preferred an appeal. In the appeal court has clarified. Firstly, there was a blanket status quo. Then the appeal court had disposed of the appeal by granting liberty to the Honorable Single Bench to hear it and has clarified that the status quo will only be upon the surface actions, not to any other actions. Today, my lord, when we have went for the insolvency and bankruptcy proceedings, my lord, now they have once again mentioned this matter. All this through, my lord, they have never mentioned the matter, my lord. They have never moved this matter. They were enjoying a stay. Since, my lord, the NCLT is taking up the issue whether the account has been classified as an NPA, my lord, these are the two dates where the NCLT that when the account was classified as NPA, my lord, the NCLT is looking into that issue, my lord. They have mentioned the matter. My lord, I'll be placing the order of the Honorable Division Bench also.
No, now you are proceedings under the insolvency
Bankruptcy court.
code.
There is no status quo, Lordship. This is the order passed by the Honorable Single Bench, Honorable Division Bench. Division Bench final order টা যেখানে ক্ল্যারিফাই করেছিল কিসের উপর স্ট্যাটাস কো থাকবে আর কিসের উপর থাকবে না. If your Lordship sees, my lord, at page number 2, the third last paragraph.
So you initially initiated proceedings under surface here.
Lordship.
Thereafter, insolvency
Yes,
proceedings.
Lordship. Lordship kindly sees the order.
I am considering the explanation of 26E
Lordship.
of the Surface Act that says that for the purpose of it is hereby clarified that on or after commencement of insolvency bankruptcy court, in cases where insolvency or bankruptcy proceedings are pending in respect of secured asset of the borrower, priority to the secured creditor in payment of them shall be subject to the provision of that code.
Lordship.
That means in respect of the proceedings which initiated prior to
Yes,
initiation.
but we have initiated later on.
And the proceedings under code is to be initiated first. Then
There is no mandate in that regard. If it is if it is, my lord, initiated at the first instance, then, my lord, over the surface proceeding, the insolvency and bankruptcy proceedings will prevail. That is the law. My lord, we have initiated later. My lord, kindly considers the Honorable Division Bench's judgment once, my lord. Page number 2, third last paragraph.
of which judgment?
My lord, the
Division-
Honorable Division Bench's judgment, my lord, arising out of this writ petition, where the bank has moved an appeal because of the grant of status quo.
Yes.
If your lordship sees, my lord, third last paragraph, at this stage, a prayer has been made by the learned counsel for the respondents that though in the writ petition, the actions of the bank under the Securitization Act is under challenge, but on account of the order or status quo, the other actions which are permissible in law at the instance of the bank are also held up. Therefore, to that extent, the order of status quo be clarified. Learned counsel for the appellants, my lord, which was my learned friend, I have made a mistake. My lord, initially they did not get an interim order. They have moved an appeal. My lord, in the appeal, there was an there was an order of status quo, and this is the final order. Lordship, then it says that learned counsel for the appellants has failed to put forth any justification for continuing such a blanket order of status quo. Having regard to the circumstances of the case, we request the learned single judge to decide the writ petition itself as early as possible, preferably within a period of 1 month from today. Till the writ petition is decided, the respondent bank is restrained from taking any further proceeding as against the appellants under the Securitization Act. Only the Securitization Act. There is no order of blanket status quo against any other proceeding, your lordship. Well, this
But court refused to pass any blanket order of status quo.
yes. The blanket order of status quo was there. That was crystallized and said that only upon the Securitization Act. After 13-2, my lord, we couldn't proceed since there was a status quo. We have moved before the
So if
insolvency.
you rejected their proposal for reconstruction,
Yes.
what prompted you to again issue a letter in 2021?
Lordship, we have
After declaration of the amount, after you declaring
again,
the amount as account as NPA,
Lordship.
what prompted you to issue another notice in 2021?
So their representation prompted us. They were constantly giving the representation. Now, my lord, kindly say
That means it give a impression to the readers of that correspondence that the proposal has not yet been finalized by you,
there was
still under consideration.
no, your lordship. It was rejected. Again, they have given a proposal. My lord, that was also rejected in 2021. That is the letter of 2021 where it has been stated that you kindly give us. My lord, the bank is not against restructuring. My lord, the criteria of that was not fulfilled. And my lord, restructuring is not a right, my lord. It is not mandatory. We have, my lord, what is mandatory? My lord, what is mandatory is to adhere to the circular of the Reserve Bank of India. What we have done. The Reserve Bank of India circular says that every bank and NBFCs must have their own circular regarding MSMEs. We have our circular. They have given their representation, my lord. The representation was considered, declined, again given representation, again. My lord, the last thing that the bank has asked for the TV reports, my lord, they have prayed for time.
Where is that order or where is that communication
My
that
lord,
for this reason your prayer or proposal has been rejected?
first is
You
there.
reject.
Lordship,
You reject
Lordship, first
that your proposal is not fit to be accepted and hence rejected, and it is the ground for rejection.
Lordship, first letter I have shown when it was declined. Constantly, my lord, they have been giving representation, and my lord, what has been shown by my learned senior friend, my lord,
You
a letter-
show that you rejected their,
my
they
lord,
are claiming that there no communication, no correspondence from your end to them disclosing the reason for rejection.
my lord,
Why you have rejected?
my lord, I believe that prima facie, I was able to establish that the bank has rejected it via communication dated 6
How?
March
It
2020.
is your claim.
My lord, I have shown
It
the
is your claim. Court has not declared.
notice, my lord. My lord, I have shown the notice. I have informed the court what was the predicament at that point of time. Why I did not get. If a liberty could be given to me, I will.
Even that answer court has not got from you. That what prompted you to issue another letter
My lord,
in 2021 after you declared the accounts at NPA.
My lord, because there was another proposal from them on 22/2021. That is why, my lord, we have rejected. That is why once again, my lord, there was another communication from the bank. My lord, they have been constantly giving their presentation after the declaration of NPA. My lord, they did not come up to the court. They have come up when 13-2 was issued. My lord, I would have understand that after the NPA was declared, my lord, they have come up to the court stating that my representation was not there. They have not adhered to my representation, and straightway I have come. They have waited. They have waited the time till the 13-2 was there. Now to stall the entire surface proceeding, your lordship, this writ petition was there. If lordship would give me that liberty, I'll place all these documents on record. Why it was rejected, my lord, I'll place
A
all-
matter of 2021.
lordship. I'll be placing documents prior to that only, my lord. which
What
say-
prevented you to annex all the document in your affidavit in opposition?
If my lord kindly sees the date, it was 7th of August 2020. My lord, I did not get the documents at that point of time. My lord, thereafter, when I got, my lord, the liberty was not there with me, my lord, to file it. If your lordship gives me that liberty, my lord, I'll be fine. They can counter that, your lordship. They can counter that.
Or
at
have
any
filed
point
a
of time.
supplementary affidavit. They didn't choose to use an affidavit to that extent also. They could have annexed that document, which has been fallen from your lordship. Law says if there is a pleading, you can place the document subsequently.
My lord,
No
after
pleading, nothing.
my lord, after the supplementary affidavit, my lord, liberty was not given to the respondents, my lord, to
You
file
should
their
have prayed
opposition.
for.
My lord, thereafter the writ petition came and they did not appear. My lord, and they did not appear. It was the order passed by Honorable Justice Shokoshaji Bhattacharya.
My lord, senior was not there. After it was filed under procedural. I appeared, they were not present.
My lord, prior to that.
I for my lord that the matter should be heard. As they were not there, that is not done.
My lord, I believe on that particular day there was some resolution.
I have vivid memory that I appeared.
My lord, I'll be placing that order also. That where we have appeared, my lord, they did not appear. My lord, the liberty was not there with me, my lord. Without the liberty, how can I file an affidavit? If your lordship gives me that liberty, my lord, any day I'll come up with an affidavit. They can use their reply.
How long? There is a direction,
My lord, within 1 day.
there is a,
These are
di-
admitted documents.
there is a direction from the Honorable Division Bench upon the Honorable Single Bench that you dispose of the as expeditiously. So you got, when you filed affidavit in opposition, you said
7th of August, 17th of August, 2020.
after Division Bench order or before that?
To that.
After division.
After division
After division bench's order.
So
carry on.
Lordship kindly sees, my lord, this order on 29/11/2021. The matter came up before the list of our coordinate bench of your lordship, my lord. We were present on that particular day. For the lack of determination, my lord, it was released. They did not appear, my lord. We also did not get the opportunity to use our reply to that effect to the supplementary affidavit. If your lordship sees this order, well, they were not represented on that.
Last, may I just address your
Let
lordship,
me
my lord.
sing it.
Last 4 years, my lord, they have not bothered because, my lord, they are enjoying a stay from the division bench of this court. Now, my lord, after initiation of the proceeding under section 7, my lord, before the National Company Law Board, my lord, they have, my lord, come before this court and mention this matter. Now, my lord, kindly consider division bench, my lord, has already clarified. Only, my lord, there is a status quo regarding the service action, nothing else. Now, my lord, I'm putting this question to myself. My lord, they have approached before this court, honorable court, my lord. They could have approached before this honorable court, my lord, at that time, my lord, when the restructuring proposal was rejected by the court, rejected by the bank.
On 2020.
why is that rejection
My lord,
order?
it's not a matter of right. Lordship, my lord, I don't know, my lord, what my junior has appraised your lordship, my lord. It's admitted fact due to the COVID, my lord, certain documents, my lord, we could not gather, my lord. It's part of, my lord, the latest part of us also. But my lord, every single communication is there. Every single communication is there. My lord, in restructuring proposal, my lord, we has to reject it or accept it. After that, my lord, we can proceed in other action.
Yes.
We have rejected. We have rejected.
Why is
But
that
my
rejection
lord, my lord, kindly, my lord, give me an opportunity to place all those documents. It's required, my lord. It's required. To adjudicate this case, my lord, these documents are required. My lord, it's required to be, my lord, produced before this court. I'll satisfy your lordship on the ground.
After 6 months, 2020, on 18 to
Yes.
2020 also is
Yes, the
rejected.
several communications are there.
They have not.
Now, my lord, they should have approached this court, my lord, after rejection of proposal, not after invoking of the surface action. This is, my lord, a well-planned, my lord, a petition to stall the entire recovery proceeding. Interim order has been refused by this court. They prefer an appeal. Appeal was firstly directed. This is a commercial dispute. Go before the mediation. Mediation failed. My lord, we approach honorable court, my lord, with an application for, my lord, modification.
Now, yes,
Yes.
since you have already initiated a insolvency
Yes,
proceeding,
yes.
then surface action.
No. It
Or
has
the-
not admitted yet, my lord. There is a development, my lord. I don't know with my learned trader applies the lordship or not, my lord. There is a diversion view of the members and the judicial member and technical members. Matter has been referred to the, my lord, honorable NCLAT.
Regarding which?
Regarding this,
Malad,
I'll come back with the order. Those orders are required. Malad, this matter is pertains to 2021. After that, Malad, many things has happened. Many things has happened. Several other 4 appeals have been pending before, Malad, the Honorable Chief Justice. Those circumstantial development I could not bring.
Now, since you have initiated a proceedings
Yes.
under section 7 of
Yes.
IBC code,
Yes.
so the surface action you itself repudiated.
After admission for 180 days.
You
After
repudiated.
admission of 180 days.
Have you brought the book, Surface Act?
Nothing.
26E.
This possible
26E.
we are not saying anything.
Hmm.
So for this possibility.
They are, my lord, only why you have rejected my proposal? Your
26
justification is bad.
E explanation.
Yes, I have rejected.
I am reading for you.
Yes,
For the purpose of this question, it is hereby clarified that
yes,
on or after commencement of insolvency proceedings such and such,
yes,
in cases where insolvency or bankruptcy proceedings are pending in respect of secured assets of the borrower, priority to secured creditor in payment of debt shall be subject to the provision of that code.
grateful to your lordship, my lord.
That means if the insolvency proceeding is started
Yes,
and parallelly SARFAESI Act is going
apart
on,
from the proceeding
that
pending
means
before High Court.
proceedings, insolvency proceedings will get priority.
Yes,
Once it is
apart from the
admitted-
proceeding, my lord, pending before the High Court.
And once it is admitted,
Yes.
proceeding will start.
I
After,
thought
my
they
lord,
have
the
challenged
moratorium period will be
SARFAESI
start,
Act.
my lord, once it is admitted. Moratorium period, so for the 180 days will be start after it got admitted before the tribunal. It's still on admission stage.
I have placed the bolo আমি place করেছি
I'll place it. I'll place all these documents. I'll place all these documents. But a supplementary affidavit is required to bring all those future event. Now, if my lord, I'm admitting my lord, what is foreign from your lordship, my lord, certain documents required to be annexed, we have not annexed. But my lord, if kindly lordship kindly grant me liberty, bring all those future documents, my lord, future circumstantial development, that will clear, crystallize the scenario.
No, how? I advise liberty can be given since today they have filed supplementary affidavit.
Yes.
Today you have received.
no we have received long back my lord we did not
So
get-
you did not express your intention
No,
to
supplementary-
to use your exception.
Yes.
my
I'll,
lord, we did not get an
before my lord,
opportunity.
sitting in
Mr.
a
Sahara,
this
what
court,
can
my
be
lord,
done?
lordship has power to extend the time
Yes.
for adjudication of a case.
Supplementary reply দেওয়ার, ইয়ে
No,
দেয়।
no, there is no.
Okay.
I'll come back.
Let me hear Mr. Sahara. Yes.
Yes.
They are now seeking.
First of all, I have not cleared my supplementary. Kindly come to the letter of the
না not relying
Signature.
on document দেখা
Signature.
6120
Yes.
Is there any acknowledgement?
Yes. Hence I accept. Whether any.
I'll produce, my lord. Kindly, my lord, kindly let me come back. I'll produce, my lord. Keep this matter on Monday. I'll come back. I'll come back.
Okay. Allow. You have stated.
I'll come back.
You express your intention to bring
Yes.
certain documents on
Yes,
record.
yes. I'm grateful, my lord.
Okay, certain
grateful.
subsequent document and future subsequent development.
Yes,
Now, in respect of your pair,
yes.
what is the stand of the petitioner? Let the court ascertain.
I'm sorry.
Learned friend, you are being
Sorry.
over enthusiastic.
Is my
At least
I have learned
today
many
they are
things
not
from
in a
him, my lord.
position to show before your lordship that any rejection order at least served upon us.
হ্যাঁ দেখো it
So,
is there with you
there is no pleading in the opposition that one particular day we have rejected your prayer. First, even if we make a further representation, after rejection can be reopened the same. I am asking one question to myself. A NPA account can be restructured.
thereafter were declined
No answer so far the NPA is concerned.
pleading হয়েছে
My learned friend not uttered a single word. Why during the period of COVID you have declared NPA? Not a single. Even if I made representation, can they consider after NPA declaration? So far restructuring is concerned. Now your lordship kindly see the pleading, what they have stated in their opposition. My learned friend say there is clear indication that this letter has been served upon us.
So you are not relying upon your supplementary affidavit.
Absolutely.
So take it.
Single document from that.
So you take it back. হ্যাঁ এই ওই লাইনটা কেটে দিন তো Yes.
But I have not placed any
So now
paragraph 8.
court is called upon to decide the issue based on the documents brought on record by the parties.
Now, my lord,
What?
one line answer regarding the non-performing asset, my lord. My lord, the reserve guidelines of the বলে দিন আপনি NPA এর answer টা দিয়ে দিন regarding my lord, regarding the non-performing asset, my lord, the Supreme Court has told, my lord, after declaration of COVID, my lord, bank, no institution can declare any asset as non-performing asset. If the dues is prior to that, If the dues is prior to that, then we can classify the asset as non-performing asset.
Even
That dues-
during
2000
moratorium period,
Moratorium
moratorium period.
Moratorium period was decided by the Supreme Court after declaration of COVID. After declaration of COVID, if someone due is before that, 1 year back, 6 months back, then we can decide it. We can classify it the same. কোথায় Supreme
Yes.
judgment এ আছে? Yes,
90 days period starts.
yes. হ্যাঁ বলুন বলুন।
Now you're
So moratorium will be given to who? To which account?
It is prospective.
Which was
those
which account?
account, those account,
You when being over enthusiastic you are making. Reserve Bank has said give moratorium.
yes.
Moratorium means that already dues continue process is going on. Now you give. But there is a existing loan. A moratorium on which?
That-
On the payment of installment of a particular in respect of a loan. That means loan is going on.
অলরেডি হচ্ছে ডিফল্টে চলছে সেগুলো মনিটরিয়াম ভ্যালু
Let me come on Monday, I'll be back. Answer. Monday, nothing. Heaven will fall, I'll answer. I'll answer. Yes. Lordship, kindly allow me to file a online supplement, one page supplementary affidavit. I'll bring. That is required. That is required.
you file your notes of argument,
ঠিক আছে।
but I take up their opposition.
কি না বলুন সব বলুন, আমি মানডে বলবো বাকি যা বলার।
Only, আবার এখানে মামলা থাকবে।
হ্যাঁ থাকবে।
আমরা থাকবে।
I have 700 matters. So much time cannot be given. I have given.
Monday morning, one day
হ্যাঁ।
nothing will happen. Monday morning.
You consider.
Let him argue, we shall not come. Kindly take up
Yes.
this time of the opposition.
Will give reply.
Relying on this document of 6 January 2020, while undertaken, submitted that there is a clear indication that this document has been served. What has been stated kindly about this file? One is that we place
Yes.
the restructuring proposal submitted by the petitioner were declined and thereafter the petition number 5 presented the petition number 1 submitted a representation on 11th May 2020. Before the marriage data was according to case, after cancellation, we wrote a letter to them on 11th. I'll take up my 11th May letter at page 110 of the petition.
Yes.
Is there any whisper about this communication? Alleged communication? The document which has been placed before Lordship, an argument was advanced that after serving this notice, you have given a letter to them on 11th June 2020. Guys, take note of it. There should have been a reference that we have received this and this is our reply. Their submission is that we have submitted our reply to the 11th May. It's an unless demand justice to proceed with the restructure. There is no whisper about any communication that our plan has been rejected. Now, after 4 years, a document placed before Lordship without any acknowledgement, nothing. They are not saying that this has been served upon us. Had it been served upon us, there should have been an acknowledgement of any of my clients. No whisper, not a single document I have stated that this document has been served upon us. Even they have written so many letters. Not a single letter discloses that on 11th May 2020 we have already rejected your prayer. The question is that whether twofold. First, restructuring the scheme, which has been with no alternate time and again Supreme Court says mandate binding upon all banks. Unless you reject it in a valid form. There is no rejection till today. Then my lord, I will take note of my lord 80. Admittedly, during the period of COVID, when the circular was by learned friend, a new logic has been sought to place loan which was taken during the course of COVID only can be considered. This is not the law. Loan has been taken prior to COVID, even there was defaulter. Supreme Court says no, there should not be any declarable. that has been upheld by the Supreme Court time and again. My learned friend has not submitted single line so far the judgment I have placed before your lordship. These are the binding effect.
Student here, take some time to come back.
No, it cannot be
I will not
piecemeal.
consider
That
judgment.
cannot be piecemeal. Definitely you should have.
Huh?
Whatever you
What judgment is?
after giving my reply,
I
you
will
will place a judgment. I am giving my
In the
reply,
senior
sir.
member of this kind
I am giving my reply.
this kind of
sir.
submission is very big.
Absolutely, you have the right, but you have to make it clear.
Right. No, I have to write what judgment.
I am giving
right
the
to come.
what
I have right to consider.
I have already given to you.
But today morning, just now you have.
Then, my lord, 1 second, kindly consider these aspects of the matter also.
Today morning you have got the brief.
No, the judgments. The judgments.
Reported judgment.
Maybe.
What says that the reported judgment has to be handed
I
over?
cannot be accurate.
You should make yourself ready.
One day I will answer the judgment.
So, these are the points which I have read. If you are kindly pick up the matter wanted to mention, you shall submit on your support. If you desire, you
I'll
can
come back.
submit.
I'll come back.
Learned counsel, when the learned advocate of the petitioner was submitting today, then a thinking come in my mind which judgment they can rely upon. Where they are going to, where they are going to. And you are in the,
Lordship knowledge and all
you are dealing with this matter since 2021.
May I, Milord?
You say, I have stated
After
that
giving
he-
my reply, how he will take it?
I have stated that are you indicating the judgment of Ponit? Yes.
I was not there, Milord. I
Oh,
understand, Milord.
eh,
Location I have.
tendency of their argument is indicating the same.
Civil location I have appeared before Lordship, Milord. I know. Lordship, Milord. So, well, any matter.
Should have come with,
Yes.
should have come. Eh?
What with notes of argument on the one?
Monday morning, Milord.
Are the learned advocate appearing for the respective party leaves the matter for further consideration?
Yes.
On Monday, on 14.
Further consent is required.
On 14 at the top of the list. Okay, HR 14 the parties have had liberty to file their written notes of argument on that date. That's okay? Yes. আমার একটা কাগজ তলায় পড়েছে, হ্যাঁ? Parties are at liberty to file written notes of argument. Okay. Yes.
I'm sorry, Milord, I could not appear to Lordship, Milord. Starting of the matter, Milord, I was engaged in division bench, Milord.
DC council to
Okay, okay.
I'm fucking বলবেন না। আপনার মতো হওয়ার চেষ্টা করছি আর কি।
Actually, you consider it is a
Yes,
matter of
yes.
you can rely upon that document
Yes.
which has been pleaded or which has been referred to at least in the correspondence.
Yes.
Otherwise, it would be not possible for the court to accept that document on record and to consider the same.
I will satisfy your
Okay.
Lordship, Milord. I
Eh,
will satisfy your Lordship. I try to satisfy your Lordship, Milord, regarding Milord, whatever pleaded, Milord, in the writ petition, I will try to satisfy your Lordship.
Yes, yes.
I will try to
So-
satisfy your Lordship, Milord.
So both
Yes.
both of you are requested to confine your argument
Yes.
within the pleadings. Okay? Yes.
Yes.
I shall not make any further statement, shall only hand over the notes of argument.
Okay.
After reply, possibly.
No, I will answer, Milord. I will answer. I tried to answer. I try to satisfy your Lordship, Milord, regarding the judgment and one of the points.
Okay, keep the door open. If
yes.
anything is to be, yeah.
Yes.
Okay. Okay. Okay, next. To be mentioned or at the top. At the top, yes. Same position, yes. Item number 2. Yeah.
Lordship, the matter was heard by your lordship on 8th of June, but unfortunately, the which I have obtained from
My lord, I appear for the petitioner in this matter.
appear in 18th of July, May. This week by your lordship on 31st of July or 2 p.m. lordship. Here is the server copy and here is the order. Here is shown that it is 8th,
Order says 18th July.
Yes, my lord.
but by your lordship, it was fixed on 31st July at 2 p.m. lordship.
My lord, paragraph number 10 of the order says, taking note of the claims and rival claims advance by the party list this matter for further consideration on 18/7/2025.
Okay, let it appear on that date. It would be fixed on 37 দেখি এটা কি আছে
অর্ডারের কপি ওটা
18/7. It was directed to appear
On 31st
31st.
at 2 p.m.
And the server copy from that there is also showing that it is showing, but it
করে দিন
typical mistake also.
করে দিন এটা তাহলে বলছে যখন ঠিক আছে না এটা টু বি মেনশন না ওই জন্য দিয়েছে আচ্ছা বাই রিজন অফ এ টাইপোগ্রাফিক্যাল এরর আচ্ছা in paragraph 10 of the order dated 18th July 2025 it has been erroneously recorded erroneously recorded that list the matter for further consideration on 18th July 2025 in place and instead of list the matter for further consideration on 31st July 2005 at 2 p.m. To be taken at 2 p.m. Okay, since both of you are saying. Yes, next.
Grateful, my lord.
Oh, what good.
My lord, appear for the Nadia Jilla Porishad. My lord, appear for the Nadia Jilla Porishad. Yes, ma'am. My lord, item 2. There was some
Oh,
technical
that
glitch.
matter. That matter. Huh?
My lord, it was appear on 31st of my lord, July.
Okay, okay.
31st July, my lord.
Yes. That means the matter has been referred to the district magistrate,
My lord. Yes, my lord.
My lord,
Yes.
who will resolve the issue, who among the two
Jilla
courts
Parishad
will
and-
play.
My lord.
Yes, now I can recall.
Yes, my lord.
Hey, sorry, এটা ফেলে দিচ্ছি।
দাদা।
Yes, the next matter. কোনটা? না, to be taken at 2 p.m. বলে দিলাম। হ্যাঁ, specially fixed matter হবে। Yes, to pay sum of rupees as compensation in lieu of that and not by any installment to the patient. Yes, what's the matter about?
Appearing for the petitioner, my lord. Over here, the order passed by the West Bengal Clinical Establishment Regulatory Commission has been challenged. Here, my lord, the uncle of the petitioner was admitted after an episode of cerebral stroke at the concerned hospital on 21st of August. After being admitted on 22nd of August, a swelling was detected in the right side of his hip. Right side of his hip, a swelling was detected on the 22nd of August, 2021. Thereafter, 25th August, an X-ray was conducted, and eventually on 29th August, a surgery was performed because a fracture had been detected in the neck femur of the concerned patient. Ultimately, the patient was discharged on 11th September. The total hospitalization cost came to about 4 lakh something rupees. Approximately, I shall give the exact figure, but it was around 4 lakh rupees. I made a complaint to the commission stating that the fracture took place while the patient was under the care of the concerned hospital. The commission accepted the complaint and the hearing was also conducted. In the hearing, there has been an admission on part of the hospital that the fracture happened in course of the treatment while the patient was admitted. Ultimately, the commission gave me a compensation of 1 lakh rupees, and that 1 lakh rupee has been paid. However, I have come up challenging this 1 lakh rupee compensation, saying that I should be paid higher. The basis of such claim, my lord, is that on 22nd, the concerned doctor, while he was on his rounds, he detected a fracture in the right side of the hip. Kindly comes to the exact page, I shall be able to address your lordship better. Kindly comes to page 75. That is the starting page of the order passed by the commission.
Yes.
Kindly turns over to the next page, page 76.
Yes.
First line, on August 22nd, 2021, while on round, Dr. Biswas noticed swelling, sorry, my lord, it's left side, not the right side, stand corrected, swelling at the femur neck over the hip joint left side. Now, ultimately, on August 25th, an X-ray was done. And now the date of the operation, my lord, shall be found from the reply given by the doctor to the complaint lodged by the patient party.
Hmm.
That reply, my lord, is at page 73. Kindly seize the last line of that page 73.
Yes.
After 2 units of blood transfusion and other preparations of the patient, OT was done on 29th August. So, my lord, from the date of detection of the swelling, which was on 22nd of August, X-ray was done after a delay of 4 days on 25th August. Surgery was done after even more delay of 4 days on 29th August. This patient, my lord, was a 73-year-old man. 73-year-old man suffered a cerebral stroke and he was kept waiting for a surgery for 7 days. On the 8th day, the surgery was done. Now, my lord, I state that this amounts to a deficiency in service on part of the clinical establishment. As per section 33 of the West Bengal Regulatory Clinical Establishment Regulatory Commission Act, under section 33, the commission can award compensation of up to 3 lakhs in case of simple injury, of up to 5 lakhs in case of major injury, if such injury has been caused during the course of treatment as a result of negligence or any deficiency in service. Now, my lord, if I allege negligence, then perhaps I will face some problems, because a division-based decision states that if I allege negligence against the concerned medical professional, I have to go to the medical council. So I will be ousted from this court if I allege medical negligence against the concerned professional. But here I allege deficiency in service on part of the clinical
establishment. Yes,
Yes.
I understood.
My lord, the commission has come to a finding that a compensation of 1 lakh rupees would be sufficient.
Sufficient.
However, my lord, subject to correction, this finding of the commission does not take into account the fact that a 73-year-old man, after a delay of 7 days, underwent surgery. It ultimately led to a degradation of his quality of life as he was wheelchair bound. He did not fully recover, and at present, my lord, the concerned patient is dead. He has died. Now, I cannot say with great responsibility that the treatment was the direct cause of his death. That would be too much of a stretch. However, it is settled, it is quite evident that because of the delay in surgery, my prognosis was affected and I was bound in a wheelchair. This aspect was not perhaps gone into by the commission. Next, my lord, it has also been admitted by the hospital that the patient also suffered bed sores. My lord, bed sores
During his stay in
the hospital.
hospital.
It is admitted. Now, my lord kindly appreciates bed sore only can happen when the patient is not properly overseen during his stay in the hospital. Because bed sores are something which is very much detectable, but they weren't able to detect, and they have admitted that the bed sore happened during the stay. And the commission has also come to a finding that no suitable explanation has been provided by the concerned doctor as to why bed sores happened despite being under the care of the hospital. They have not been able to furnish a proper explanation. Now, my lord, why I say this is a deficiency in service? I have a medical research paper. I don't know how far I will be able to impress upon this court using that document. Over there, it is shown that in elderly persons, the success of prognosis or the positive nature of the prognosis decreases with a delay of about 24 to 48 hours in hip replacement in case of these kind of fractures. Now, my lord, here the delay was over 7 days. I was kept waiting. Thereafter, surgery was done, but I was relegated to a wheelchair. Now, today, every hospital, and I'm sure in the hospital where the patient was admitted, had assured me that proper treatment will be done, because that is what every hospital should proceed on. that please admit your patient here because we will provide the best treatment. My lord, that subject to correction gives rise to a legitimate expectation on my behalf that I shall be properly taken care of by the hospital. My lord might object to that by saying that this principle of legitimate expectation finds place in administrative law. It does not and cannot be extended to these matters. However, Supreme Court, my lord, in 2009 has extended this principle to cases of medical negligence, because the Supreme Court is saying that when the when the hospital advertises that it will take the best care possible, the patient is under a legitimate expectation that he will be properly taken care of. When it does not do so, there is an infraction of legitimate expectation. Now, I may rely on that judgment if my lord wishes to peruse. So these are the main points that I deserve a greater compensation. My future, the actual consequence of the delayed operation was not perhaps taken care of. And my hospital bill was 4 lakh rupees. Out of that, 1 lakh rupees I have been paid compensation. Now, my lord, my initial hospitalization was estimated to be about around 9 to 10 days. That was what was told to me as per my complaint. That was the information tendered to me by the concerned hospital. Now, my lord, quite contrary to that, I was discharged on 11 September. The hospital is tending to give an explanation that the patient had wanted to leave his bed, so maybe due to some erratic motion, his fracture took place. Maybe, my lord, maybe that was the case. Admit, for the sake of argument, maybe that was the case. But he was under your care. You detected that there is a swelling. You did not do X-ray for the first 4 days. Then by their own reply to my complaint, operation was done 4 days later. Because as per my complaint, that the hospital demanded money for them to do the operation. Now, my lord, another judgment is there of a coordinate bench of this court, my lord, on which dealt with the constitutionality of various provisions of this 2017 Act. In that, my lord, reliance was placed on a Supreme Court judgment stating that doctors must not wait to be paid to do their surgery, or the hospital must not insist on payment before
prior to operation.
meeting out the treatment. Now, my lord, such facts in the complaint, they have not been denied per se. They not have been categorically denied. So unless and until I paid, my surgery was not done. Even though I had paid them 53,000 rupees within a day. They told me on 25th that you need to pay such and such money. I paid within 1 day. It is reflected from my complaint. Thereafter also, after 4 days, my surgery was done. And ultimately, I was bound in a wheelchair. So, my lord, this, according to me, my lord, amounts to deficiency in service. As per section 33, my lord, commission is empowered to grant me compensation of up to 5 lakhs in case of major injury. Now, my lord, I don't think this will require much deliberation, because the injury that was caused to me had to be corrected by way of a surgery. So it was a major injury. Now, my lord, taking into account that I also suffered bed sore, and if even take into consideration the degree of duty vested upon doctors, on the clinical establishment to take care of its patients, even if I disregard such heightened sense of duty, even then, if bed sore is considered to be a minor injury, I am entitled to compensation of up to 3 lakhs for the minor injury, as per section 33. And apart from that, under section 38, the commission can award me compensation
Up to
50 lakhs. That
50
is
lakhs.
50 lakhs. That is
10 lakhs was the subject.
Who is for the clinical establishment?
My lord.
Who is for the
Clinical
you are for the commission. You are commission. Yes. In one matter, you appear on behalf of the commission. Then I can recollect. But who is the Seva Magnum PPL Hospital?
Yes, my lord, the affidavit of service being kept, it's an old matter.
But if,
Hmm?
but if it is enhanced, the compensation has already been granted. I have nothing to say. Because, my lord, the commission has already given.
No, your decision directing the clinical establishment to pay 1 lakh without looking into your order, prima facie suggests that you found that there was a deficiency of service. Now question is what would be the quantum of the
That is
compensation?
up to your lordship. That
He is aggrieved with the quantum of that. He is saying that it should not be 1 lakh, it is more than that.
is up to your lordship, but I cannot say.
No.
My,
No,
that has to be adjudicated by your lordship.
My lord,
yes, he is showing that he suffered bed sore.
Yes,
That means the
from
patient
order sheet-
who
from
has
the order
died,
sheet It appears.
who is since disease, he suffered bed sore, and there was a delay in giving proper treatment to
Yes,
the
my lord,
patient.
Dr. Bishwas, my lord, who conducted at the time, who was at the time of hearing, he surrendered before the commission, and he has.
Okay, so it would be better, Mr. Chakraborty,
Yes, ma'am.
you
serve
serve a notice,
yes
because whatever payment would be made
by the hospital.
by them, so they can claim that in our absence the order has been.
No, no, my lord.
Aja, having heard the learned advocate appearing for the respective parties and upon perusal of the materials
Thank you. খুব ভালো।
ওটা তো অন বলে দিন, ওটা দরকার নেই, ওটা তো অন বলে দিয়েছি। Yes.
I am for the petitioner.
My lord, I am application of 1, my lord. Petition of 1, my lord.
Order, my lord, I have served and state has appeared.
I'm for the statement.
And this is in respect of dues which I have worked for the purpose of election duty since 2010 to 2007. Page 14, can you see? Straightaway page 14. Out of 11 lakhs, 3 lakhs something paid, balance amount to be paid. It is written by the next page subdivisional officer.
Who is for the state?
I'm for the state, my lord, led by Mr. Galib.
Maybe what is the dispute? Why are you not making a payment?
Yes, my lord, I have stated.
You have
they
exploited
paid.
their service, you have utilized their service.
Your lordship. Your lordship.
You have completed the election, all work related to election. Now you
Lord.
pay.
Yet to receive instruction, my lord.
Whenever the matter will be resolved. Why You have not, you knew the matter will be appear. It will,
Lord, yesterday I received the brief, my lord.
it's
Because it was granted,
2022 matter.
my lord,
I think it was served upon the state much earlier.
my lord.
Eh?
Yes. And
You have got,
your lordship.
it has been currently allotted to you,
My lord,
but it was served upon the state much earlier.
my lord.
And that, well, 22 to 25.
এইটার নাকি
Plus interest also. I'm entitled.
So what can be done?
And your lordship judgment, my lord, already settled the issue. In respect of contractual matter, if my lord,
What's that?
it is reported, just current volume. Can you see?
Lord, if your lordship kindly grants me 2 days of
Okay, it is the rule of battlefield that
Matter is
none should be killed
Kindly see.
who is without any weapon. Okay. Or that judgment.
Yes. Current volume it is reported. 2025 volume 2. And SDO has sent it, admitting this.
Well, that is another okay. That is.
Judgment is not required. Even then, my lord,
You take instruction.
my lord.
When you give the date.
my lord.
You give the
Wednesday,
date.
my lord.
Wednesday. Okay.
Yes, Wednesday. You will also fix
Acha, yeah. Acha, what's your name?
Monish Bishwas, my lord.
Acha, Mr. Vishal, learned advocate appearing on behalf of Mr.
State.
Galib. Acha, learned senior counsel.
Senior government advocate, my lord.
Learned senior government counsel. Acha. Acha, press for a short accommodation on on behalf of the state. State for a short accommodation on behalf of the state to avail necessary instruction. ঠিক আছে? Stop. মিস্টার আত্ম তাহলে মিস্টার গালিবের নাম লিখতে হবে। দরকার কেরিং তো মিস্টার বিশ্বাস সাধারণ স্যার লার্নেড অ্যাডভোকেট অ্যাপিয়ারিং অন দ্য বিহাফ অফ দ্য স্টেট আচ্ছা প্লেস ফর এ শর্ট অ্যাকোমোডেশন টু অ্যাভেল নেসারি ইনস্ট্রাকশন ঠিক আছে হ্যাঁ ইউ আর গিভিং দ্য নেম অফ মিস্টার গালিব
My lord, he is in court, my lord. He is engaged in court number 2, my lord.
নাম দিয়ে দেবে আই মিস্টার গালিব হ্যাজ কাম
We are waiting for it.
So your junior has
Qualified apology.
praying for a brief accommodation
Cannot.
to take instruction. Why you have not paid?
Innocuous prayer.
Huh?
11 লক্ষ টাকা due আছে।
Very good submission. So I am directing.
No.
I am directing the SDO.
টাকা চাইছো তো?
You pay.
Asking for two mandamus.
Yes. Why not?
No, he has preferred a representation to.
No.
In fact, they have said
Admitted কোথায়?
3 lakh টাকা দিয়েছো।
3 lakh.
I am to substation against that.
Money
that
claim. Lordship, kindly.
consideration justice.
No, Lordship, it's a money claim of 29.
Money claim, you say
2019.
it is admitted position, so there is no dispute. So I do not find
Admitted
that anything should be left to the authority to be decided.
Lordship, we have admitted 8,17,000. What he is praying for?
Yes.
কোথায় দেখাও?
তুমি এই যে দিয়েছো 11 লক্ষ টাকা দিয়ে 3 লক্ষ টাকা পর্যন্ত। দেখো,
কোথায়?
এসডিও পাঠিয়ে দিয়েছেন ডিস্ট্রিক্ট ইলেকশন অফিস।
কি বলেছে? DM is Lordship calling.
They have submitted representation.
May it be on Wednesday, Lordship. Let us come with the instruction from DM.
Yes.
Otherwise, I'll be in a predicament.
Yes.
Something be on record, Lordship.
Yes. Mr. Galib, learned senior standing counsel appearing on behalf of the
Government
senior government advocate on behalf of the state appearing on behalf of the state prays for a brief accommodation to avail necessary instruction. Stop. In view thereof, the matter stand adjourned. Place the matter in the list on on 16th July, 16th July হবে তো? আচ্ছা 16 July ছেড়ে দিন, on 18th July. On 18th July for further consideration. ঠিক আছে? হ্যাঁ? It will remain at the top, নাকি? Returnable motion. Returnable motion, it will be appear under actually returnable motion. এগুলো তো মোশনটা উপরেই থাকবে নাকি? হ্যাঁ? হ্যাঁ, returnable motion. হ্যাঁ, under the heading returnable motion. Under the heading returnable motion. Yes. Next. আমি অনেক স্লো হয়ে যাচ্ছি, এদের সঙ্গে বেশি গল্প নিন তো, ছুটুন তো।
Item number 5, I beg to appear on behalf of the petitioners. My lord, in this matter, I'm sorry, my lord, I am appearing on to virtual mode because of personal difficulty. I could not come to court today, my lord. So I'm seeking leave of the honorable court to appear through online mode. My lord, I am in this writ petition. I believe on the last occasion when this matter was taken up for consideration, my lord, a submission was made on our behalf that in this matter, my lord, we have challenged the virus of certain regulations introduced by the Union of India, by the central government. So perhaps, my lord, we have to serve upon the Attorney General.
Yes, sir.
My lord, what we have done, we were not aware of this notification. We served upon the learned senior central government advocate who is based in Kolkata. So, my lord, what I will be seeking today is some time, 1 week's time will be enough to serve upon the Attorney General and come back.
Yes.
My lord,
আচ্ছা,
kindly.
আপনি based on the fair made on behalf of the petitioner matter stand adjourned to একটা ফাঁকা ডেট ডেকে দিয়ে দিন তো। হ্যাঁ, 1 week হয়ে যায়, 2 weeks time should be given. আবার তারা আসবে, টাইম চাইবে। হ্যাঁ, না 2 weeks একটু পরে।
Any day on 22nd or 24th. My lord, as per
একটু পেছন না, জুলাই আবার সার্ভিস করবে, ইয়ে করবে আবার। না 28, 29 ওগুলোর মধ্যে কোনটা বাকি আছে? 30th July.
my lord,
On 30th July.
my lord, grateful.
Yes. Next.
Item number 6, my lord, I'm appearing, I beg to appear for the petitioner, my lord. Mr. Tona Chakraborty is appearing for the state, my lord, in this matter. And on last occasion, lordship was pleased to direct that presence of state is required.
In courtroom number 5, my lord, I was just requested by his clerk. Passable, short passable, lordship.
Okay, not today. Next.
7.
In the matter, the petitioner do not want to proceed with the matter, my lord.
Yes. Cooperative society. আচ্ছা। আচ্ছা, ইয়ে করুন, ওই মিস্টার বন্ধুর নাম কি দিয়ে দেবেন? সাচান স্যার, লার্নেড অ্যাডভোকেট অ্যাপিলিং ফর দ্য পিটিশনার সাবমিট দ্যাট
Lordship, we are for the respondent KMDA led by Mr. Satyajit Talukdar, my lord. This matter, in this matter, all the affidavits have been exchanged, and this matter was running under the head hearing. All of a sudden, it has come under the head motion, lordship.
affidavit exchange.
Yes. My lord, what I was seeking, lordship, if my lord takes it on 15th, keeps it on 15th, my lord. Mr. Talukdar is engaged in 24, courtroom number 24, my lord.
No, it will come under the heading
Hearing should come under
ইয়ে করে দিন, ওই আপগ্রেডেড ম্যাটার হিসেবে দিয়ে দিন। Short point is involved. What is the matter about?
The petitioner
Not to give effect such and such certain memo and to release petitioner from executing the work and also release security deposit submitted tender. There is no valid or rate quoted. Oh,
After 1 week.
that means you, in response to a notice inviting tender, you submitted tender. Subsequently, you found that the rate which I have given, I shall not be able to complete that work at the rate.
No, my tender was accepted after 120 days, after 7 months.
Uh,
So they legal according for 120 days from the next tender.
oh,
That is a short question. Whether after 120 days I am duty bound or under obligation to execute the work at my court rate. Because instruction
this 120 day lapse for whom? To you and not for them.
for both of us, validity period is 1 week. Validity period my rate will be for 120 days of the given contract. I submit my tender, my actual direct copy with the work in just for one work after 7 months, in just for other work after 1.
After 1 year.
Then I say, I make it subject to revision. Take it class. Number 1. After I filed this application, during the pending of the application, my tender was terminated. I doubt that who has not been authorized under the contract term. Whether in commission and pension.
They have completed the work by engaging another. Now we are interested to get back the security deposit or earnest money deposit, EMD, whatever name it would be called in the present case. EMD you want to get back. Yes.
So I am get back my security.
Security deposit or earnest money.
Because the notes is noted where when the name person who terminated the contract with execute.
Okay, an incompetent person has terminated your tender work. Now you are not interested. And even you are not aware whether by engaging another person they have completed the work or not. So now you are only interested to get back your security deposit. What is your stand? You don't know.
No, my lord, but kindly keep it on Tuesday, Lordship.
Oh.
Mr. Talukdar is.
Now whether there is a forfeiture clause, any forfeiture clause.
Not know, my lord.
That if such and such is not done, so your security money will be forfeited. Whether any forfeiture clause?
Forfeiture clause is in the contract.
Oh, okay. They have not intimated you that your earnest money or security deposit has been forfeited.
During the vacancy, they forfeited.
Ah.
I filed that with them.
So piecemeal submission you are made in piecemeal manner. You say that my earnest money has been forfeited. So now court is to decide whether their action forfeiting your earnest money is correct or not, justified or not. You tell the same.
Judgment of critical anything.
Court is under impression that only a simple direction will suffice. You pay the refund.
Exactly.
But here they have already forfeited. Order had the learned advocate appearing for the respective party leaves the matter for further consideration when on 30th July দেখুন তো
Lord, in item number 9, Mr. Amaleshwar is appearing for the petitioner. My lord, he is in circuit bench. I was paying 2 days accommodation, my lord, today and Monday. I need a my lord after that.
Kindly keeps it
the week after the next, my lord. Monday week.
Oh. So based on the prayer made on behalf of the petitioner, the matter enjoy longer period. Yeah. 2 weeks next.
Item number 10.
10. Yes, yes.
But it's a case where the petitioner not has been the victim of at the hands of the bank. He took the loan. It's not a case that there is a default or like that. No surface proceedings are like that. I took a loan. The lordship knows when the loan is being taken, it's very small amount, 1,50,000. They take the PDCs.
Supplementary affidavit and affidavit, whether they have filed affidavit in opposition on record, it is in the, no, file. So keep it on that date, it would be, take it back. Yes, yes.
The simple case is that without the petitioner was to pay monthly installment at the rate of 1,455, total 180 installment. Now he has been paying, and the PDCs have been taken
Which
by
for the bank.
That nobody is appearing. It was served earlier, but only
served earlier. So
only difficulty, without your lordship will see that entire loan has been liquidated. They are holding my deed by an interim order. But I am praying, just let they return the deed, and the main matter to be decided. They have withdrawn. My claim is they have withdrawn excess amount from my savings account, and they have not liquidated the check but in proper time. That's why they have imposed the penal charges. But I have all the PDCs are with them. They 4 checks they deposited simultaneously.
Okay, let them come.
Yes, yes.
It is your allegation. Let them to defend,
they are
or
not
let them to present their their case.
Absolutely.
Disclose their stand.
They are not appearing.
Don't take any expertise order.
Yes, kindly fix it at an early date. I can serve another notice. I will serve another. July,
31st July, yes. End of the month. Yes, next.
Item number 11.
দেখি দিন কিছু নাম হয় আর একটু নাম্বার Okay, I mean, you are appealing.
For the respondent.
Oh, yeah. It's a compassionate appointment. So, what you understand?
But because under the present rules, first it will be considered, then it will go to the school service commission. School service commission, they have a maintained register, then that will be decided. Kindly see for a moment the rules. Page 72.
So you, according to you, his prayer may be considered.
No. Kindly see in the page 72 of the requisition.
Okay, let them come.
Uh.
আচ্ছা ইয়ে আমি ইয়ে করি আচ্ছা who is for the respondent? State of West Bengal.
This is my lord.
You served recently. Have you served?
I have served my
Today, Pankaj Haldar appeared on May. Yes, in May 2025.
I serve intimation, my lord, before mentioning. I mean, today in the morning itself, I have intimated him.
Oh, what is your prayer?
I have prayed, my lord, for the interest on the entire retirement benefit. Normally, my lord, it is done on the gratuity amount, but here I have prayed for interest on the entire retirement benefit. Why? My lord, I happen to be an assistant teacher, my lord, teacher in charge of a school. That particular, my lord, this particular teacher, my lord, before, my lord, at least 8 months of his retirement, he being an, my lord, the teacher in charge found that he has some overdrawn amount. He consulted with the administrator, make a resolution, and my lord calculated what was the overdrawn amount and forwarded to DI to take an instruction so that to pass an order so that his retirement benefit is not hampered. He was supposed to retire on 31st December 2019. No step taken. Now, my lord, I filed a writ petition. My lord, intimation given, my lord, from the school, from the petitioner himself. No step taken. My lord, prior to the date of retirement, on my lord 23rd December 2019, I filed a writ petition. This court passed an order. You take a decision within 3 days. No step taken. Now, my lord, my lord, went on, my lord, making representation, my lord, that, my lord,
to take back the amount.
You take a decision. This court directed to take a decision regarding the overdrawn amount so that his retirement benefit is not hampered. No step taken. I went on representing. My lord, it went, my lord, in vain. Now, my lord, my lord, sent a contempt notice. Even then, that was not, my lord, taken note of. After 3.5 years, my lord, ultimately my retirement benefit was disbursed, and my lord, 2 lakhs rupees was deducted on account of, my lord, tax, income tax. Had it been, my lord, done, my lord, prior to my retirement, it would not have been arising, my lord. It would have been deducted periodically. Now, my lord, that is why, my lord, I am praying, my lord, interest on the entire retirement benefit. It is up to, my lord, even this court order, my lord, my lord, I did not, my lord, since I was, my lord, penniless, I did not get anything, my lord, I could not even move, my lord, the contempt petition itself. So that is why, my lord, in an order, my lord, this coordinate directed the school authority to serve him. I serve school authority. Thereafter, my lord, the coordinate directed to give an opportunity to show that he can make an explanation in writing by of an affidavit. That is not done even.
Now, what is the component of your retirement benefit? Provident fund?
Everything.
Leave encashment, whether there is leave encashment, whether you are entitled to get benefit of leave encashment.
Leave encashment, that was delayed. Gratuity, that was delayed. Provident fund, no intimation.
Where is your PPO? Show me the PPO. Yes, page 60.
Page 60.
Yes, yes. So get. Yes.
My lord, in this matter, Pankaj Haldar appearing for the state, my lord.
EPF such and such NPF. What is yours?
Pankaj Haldar appearing for the state, my lord. I think, my lord, on 4th
You are also appearing on behalf of the state.
Oh, my lord.
Your name has been recorded. Mr. Sanatan Panja.
My lord.
Huh? So you are appearing on this. You move it.
My lord, last occasion, my lord, was direct.
So assist the court whether
Court
he is entitled to get leave encashment or not.
directed affidavit compliance.
His
That is ready, my lord.
pension amount was 38,550.
Yes.
Gross retained gratuity was 12 lakhs.
At the top, my lord, deduction due to the salary overdraft 7 lakh 41.
Deduction
7 lakh
due
44.
to salary overdraft 7 lakhs 77.
Yes, that was, my lord, my calculation.
Acha. Gratuity amount 4 lakhs 55,000. Or no, nothing. You are not entitled to leave encashment. Okay, you are only gratuity and provident fund.
I retired on, my lord, 31st December 2019. It was ultimately released.
So that the amount which was determined as overdrawn has been adjusted.
Yes, adjusted.
You have no grievances.
No. I actually, my lord, on my own calculated this amount. And in the at least 8 months prior to my retirement, I intimated the DI to take step immediately so that this can be deducted or refunded back, whatever. Now, my lord, they have deducted after, my lord, 3.5 years of my retirement.
It has been adjusted with your gratuity amount.
Yes. Yes.
It has been adjusted. Your gratuity amount was 12 lakhs. Thereafter, it comes down to 4 lakhs 55,000.
So, my lord,
after adjusting.
I'm entitled to interest, my lord, on the entire amount of gratuity. I am entitled to interest on the entire amount of gratuity because had it been, my lord, I intimate them. I am ready to refund the amount prior to my retirement. I could have, my lord, submitted, my lord, by way of return of the said amount, so that I could get the entire gratuity amount intact. That was not done. I have all documents even enclosed in this writ petition also. It is absolutely inaction, my lord, on the part of, my lord, the DI authority.
The amount which was overdone you,
Yes.
which was overdone you,
Yes.
you have utilized that amount. You have withheld the amount. So for that amount, the state cannot be asked to pay interest. And the rest amount they have withheld for 4 lakhs 55,000 and 171.
Page 22.
Page
22.
They can be stated asked that
Page 22.
You pay the
Page 22, Annexure P3. That is written by administrator. This is with reference, that is, my lord, on 15th March 2019. This is with reference to the aforesaid subject. I do herewith submit the statement relating to the benefit of next higher scale duly filled by fixation of pay in favor of Pramod Kumar Singh, such and such, the previous fixation of pay, such and such. My lord, this was done, my lord, this was requested. My lord, since, my lord, it was overdrawn, once it is, my lord, refunded back, my pay fixation would have been automatically, my lord, done by the authority. Even that is not done. My lord, mistakenly, my lord, was granted certain, my lord.
Okay, what is your stand?
Pursuant to the direction, my lord, I am filing my opposition, my lord. That is
Opposition?
Yes, my lord. That is directed, my lord.
My lord, 1 week time be given, my lord, to file reply. 1 week time.
Okay, the affidavit opposition filed on behalf of the respondent is taken on record. The petitioner prays for
13.
13, yes.
Lordship, I'm appearing on behalf of the petition. I'm led by my senior Balala Shah. He's engaged in code number 3. I'm paying for only not to read. Paying for only not to read.
My lord, kindly then, my lord, next Friday, subject to your lordship's approval.
Acha, based on the prayer made on behalf of the petitioner, matter stand adjourned for a period of 1 week.
Grateful, Lordship.
Okay, adjourn for 1 week. Next.
14.
14, I have the petitioner. This issue is pending before this honorable division bench, my lord. Interest of CPF, GPF, my lord, pending. My lord, kindly matter to.
Acha, Mr. Bhattacharya. Mr. Bhattacharya, learned advocate, repenting the petitioner submits that a similar issue,
Advocate.
My lord, I am appearing for the respondent number 6, my lord.
I appear. I am for the
15.
petitioner.
Yes.
For bank, ICICI Bank, my lord, we have received only one letter and intimation letter and the order. The copy has not, we have not received the copy of the
Petitioner, you have not served.
But instruction.
So you are for the bank. Which bank?
ICICI Bank.
ICICI. You.
I am for the respondent number 6.
Respondent number 3. Who is respondent number 3? You have seen, I have not taken the brief as yet. Respondent number 3.
Wait.
Yes, respondent number 3. That means ombudsman.
6, my lord.
6.
Yes, my lord.
Oh, private respondent.
Yes, my lord.
774 DBS Bank. So who is for 3? Most probably you have challenged the decision of ombudsman.
Not decision of the ombudsman, my lord. I wrongfully, my lord, transferred some amount, 22 lakhs, to respondent number 7 instead of respondent number 6. My lord, the reason behind this is Messrs Trading Company and Messrs Trading. I wrongfully transferred to Messrs Trading Company, respondent number 7. The actual, my lord, transfer should be respondent number 6, MS Trading. My learned friend is appearing.
You wanted to transfer the money
22
in
lakhs.
favor of respondent number 7. 7 is you. 7 is 4. So 7 is not is appearing.
Not appearing.
But you erroneously transferred it in favor of respondent number 6.
Respondent 6 is appearing.
Yes.
6. No, my lord.
So he does not owe any liability to pay any sum to you.
No. They are supposed.
Whether at any point of time he incurred any liability to pay any amount to you.
Yes, my lord. They are supposed to give me the money. Me, not respondent number 7. They have by
They
me.
have supplied, my lord, goods. In exchange of that, my lord, I have to transfer to respondent number 6. Instead of that, what my client's blunder had done, instead of transferring to respondent number 6, they have wrongfully transferred to respondent number 7.
Oh, I just said opposite. So your respondent number, respondent number 7 is not
appearing
there.
and not traceable. But I have served all of them. This is my affidavit of service.
Not traceable.
Not traceable. Well, the bank is giving that reply. Well, kindly see supplementary.
Where they for the last time carried on business.
Well, this is the place. The address mentioned in the cost title.
So 26 Banerjee Street.
Yes.
Calcutta.
Yes.
They carried on business for the last time from this address.
Yes.
Yes,
my lord.
You have served. You made an effort to serve. Yes. So what is the postal endorsement?
Insufficient address, my lord. Insufficient address.
Insufficient address means you are.
My lord, one more thing. Kindly see the supplementary affidavit affirmed on, my lord, the last supplementary affidavit, my lord. Kindly see. That is page number 4, my lord.
Yes, what have you stated?
It has been stated by the bank that they want to, my lord, refund the amount, but since they are not traceable, as such they could not. They are also willing to transfer the amount, but they could not, my lord. This is the, my
Who
lord,
is for the bank?
my lord, this is the affidavit of,
You are for the bank.
this is the supplementary affidavit, my lord, affirmed, my lord, kindly see.
Another bank is involved. DBS bank. So you sent instruction to which bank?
I send instruction to my bank, that is ICICI Bank.
ICICI Bank.
ICICI.
To send the amount in favor of
Respondent number 7.
Respondent number 7.
Respondent number 7.
So
bank is
you
DBS.
what instruction you received from the petitioner? Read petition. So you
It has been served, my lord. Affidavit of service is also there. Kindly see.
You give a copy.
I will give in the course of that.
Acha.
My lord, only one more thing, my lord. Kindly secure my amount. That is my humble prayer. My 22 lakhs is, my lord. It's a lot.
Still with you the amount?
The bank is still with you. My lord.
Copy of the petition we are not received.
My lord.
No, the fact of the case even we are not having.
My lord, they have admitted that they are with you. Kindly see my affidavit of
Okay, so don't disburse the amount. It is
kindly, my lord, kindly direct my lord that order. Otherwise,
no, you serve copy.
I am serving herein now. I am serving.
Okay, you give oral instruction that if in the meantime it is not disbursed in favor of any person, so don't disburse it. Keep it with you.
Yes.
My lord, kindly see the supplementary affidavit once for my satisfaction. The supplementary.
Okay, you bring you.
My lord, they have admitted that they are not with. That is why I am saying.
They have admitted that they will.
They are holding the amount.
Yes, I did that.
My supplementary page 6. Kindly see page 6 and
Yes.
P10.
Yes, the.
My lord, may I read this?
Relevant specific portion, relevant portion.
First paragraph, last line.
We have placed a hold on the facts, funds, against erroneous transfer initiated from your end. Thereafter, it has not been credited in the DBS bank.
No.
In account of respondent number 7 or 6, whatever maybe.
They are holding. DBS bank is holding that amount. So kindly direct DBS bank to transfer that account to either to me or to
ICICI Bank.
ICICI Bank. Then that will solve my problem. That will solve my
So
problem.
in the meantime, you try to effect a fresh service upon the respondent number.
7, my lord. This is the last known address, my lord. I have served this affidavit of service also. Supplementary affidavit also served last per my lord's last direction. I have served, but their address is not traceable. Even the bank is saying their address is not traceable. Kindly see. Their own affidavit, they are saying that they are not traceable, the respondent number 7. That is the problem. Well, kindly direct DBS bank, since they are holding the amount, kindly direct them to transfer it to my bank or to me, my client. That will solve the issue. Or my lord, even.
Okay, you try to, since you have made him as a party, so at the time of presentation of the writ petition, you realize that his presence is necessary at the time of hearing. So you make another report to effect service.
What the thing is that at the time of filing the writ petition, this address was there. But subsequently, after filing the writ petition, they changed their office address.
Address was collected by you.
Last known.
Okay. Court will find there is a presumption, 114 of the presumption Evidence Act, as well as 24 Postal Acts most probably, but subject to the condition it was sent at the proper address. And after expiry of certain period of time, court can presume that service was effected, but not before that. Postal endorsement says insufficient address.
Yes.
Okay.
But at the time,
this address shall not be available in any other record. It is for the first time you in your writ petition you recorded that address. Okay, it is your claim. So you make another report to effect service upon the such and such respondent number 6 or 7, and come another day and give a writ petition to him in course of this day.
In the course of the day.
Stop. I mean,
kindly see one humble
uh,
prayer, my lord, kindly
what
see
is
to-
your name, madam? What is your good name, please? Oh,
24
oh, Stone India.
item.
আমাদেরটাই তো নাকি?
24, yes. 24 Stone India, Stone India,
Kindly
Stone
see your lordship,
India.
last order, on the last occasion, my lord, we submitted, let court be considered. Now see the conduct till today, nothing has been given to us, my lord.
No, Stone India, I am trying to recollect that matter.
I'm telling you, lordship, kindly see your lordship last.
Oh, that means
Initially, your lordship.
the order was recalled.
Subsequently, my lord, court
Task.
officer something.
So today you are to task is to submit a report in form of affidavit.
Yes, my lord, and because my lord, I had shown the judgment where, my lord, it is a beneficial act and I should be allowed to continue where I wanted to give the money, my lord.
And consideration.
Where is your report? Although
But I appear for the protest, my lord.
yes.
My lord, only thing, kindly visualize the stand. Only for consideration also they are saying, but they are kindly see from beginning.
Well, that's what I said. Let them consider
And my lord,
that.
if you actually pass the consideration order, we are sure that they will reject. But unless they decide the same, we cannot go further, my lord.
Oh, on that date you make that pair. I on that date passed an order asking them you file written a report disclosing your stand
Regarding
in
consider.
respect
Whether
of
they
the
will
prayer.
consider our consideration.
In respect of the prayer. Okay. Yeah, Mr. Saha is requested to file a report in form of the affidavit disclosing the stand
Nothing to be done.
of the port trust with respect to the submission.
Nothing to be done. I have
So
made
you
my
recall
case.
this order.
Recall it. Whatever I have submitted, my lord, is in his mind. I cited, reported, judgment has been cited to my lord. Let the chairman consider my case in the light of the judgment. I think you don't have any objection to that.
That is what we said here on the last occasion, my lord.
Let them reject.
There are two things, my lord. Number one is, my lord, this is a statutory dues. It is very difficult to, my lord, consider a representation on this.
Reject it.
Number one. Number two is, my lord, the Supreme Court had directed that the parties must approach the High Court for a disposal of the writ petition. It may go in their favor, it may be in our favor, whichever it is. On that, we have nothing to say. If your lordship may kindly take page number 13 of Can 6.
Thanks. So protest one adjudication of the issue raised in the writ petition.
Fix a date, my lord, whichever.
I am making the tasks easier for the court. I have an application before the authority in the line with the judgment of the apex court. Let them consider it. If they reject, then I will come before my lord.
But please consider, my lord, how can I reconsider the statutory due?
Say this on your order that I cannot consider.
But it will, my lord, give rise to another round of litigation.
Yes, let us come.
Then withdraw writ petition.
This is the order I am withdrawing practically.
Cannot be,
with
because,
this
my lord,
direction.
when, my lord, in the same series of proceeding, the Supreme Court say, please take note 313.
Okay, but you file a report in form of affidavit.
No, my lord, we have.
Otherwise, the order will be frustrated.
But I was.
Although the court used the word requested.
Yes, definitely.
Court used the word requested. I don't know what, according to your interpretation, how you will interpret the word request.
Direction, but it will not be content.
No.
Okay, the court,
all orders of court are to be honored.
Yes.
Therefore, my lord, what we are saying is.
So what you want to say that since a statutory dues are lying to be paid by the petitioner, their representation could not be considered.
Yes, but
their representation could not be considered, or whatever. I should not say what you will come.
Yes.
But since you on orally you are making the submission that a statutory dues they have made certain pair in this where shows statutory dues are involved, So without considering the fate of those statutory dues, you cannot consider their pair. It is your stand. So you disclose it in form of affidavit. It would be delay. But one court of law has passed an order.
Definitely,
Don't
but-
allow this order to be frustrated.
Definitely. Well,
Yes.
on that note, I
So
cannot
I am
join
giving
in.
another week time or tell when you will come.
Well, could I make this prayer?
Yes.
If your lordship permits me, Lord, to make an oral prayer so that your lordship may modify that part, directing us to consider the representation or to file a report.
I have never,
Again.
representation that required consideration, not directly to give me.
Mr. Dotto, actually on earlier occasion, one order was passed.
Detailed order was.
I don't know whether this order was brought to your notice
No,
or
no, I've seen all the orders.
yes. So subsequently, a pair was made on several occasions. The court was insisted on removing the word upon instruction.
Yes.
It was my perception, maybe I was wrong, that if this upon instruction, these words are removed, that means person concerned is not accepting the liability of the submission which was made by Mr. Saha. So court cannot act on the basis of such submission.
Right.
Okay, so court recall entire order. Now place the matter for hearing, for face hearing. Now again Mr. Roy came. Now their stand is that I made a representation that is pending for consideration. Only one order from this court upon you, they're directing you that you consider the representation.
And the judgment relied upon.
Yes, will serve their purpose. But I said that by this time, I can record your pair, but I will direct the spectators you come with a report in form of a affidavit, considering the conduct of the post-trust on earlier occasion, considering the conduct of the post-trust. And I use the word that at least post-trust in this matter has lost its credibility. So oral submission, at least court will not incline to accept regarding their submission.
Well, may I say this?
Or otherwise, the matter will be placed, it will be hard on merit.
Well, only one thing that is absolutely nothing to do with this litigation. With my little experience working with Millard state authorities and public sector undertakings, where these officers, they are in a very vulnerable position which we don't understand, because they are always under a hierarchical system. We may not have to, we are not answerable to anybody over here, but the persons who are in a hierarchy, obviously, they are answerable to his superior, the superior above him. And therefore, these kinds of, what should I say, stepping back arises. So, but I personally feel, Millard, that yes, the officers must be very, very careful
Yes.
before making any submission, because
That
finally,
means they do not want to undertake any liability. Whatever they will do in compliance with the order of the Honorable High Court, in terms of the order of the Honorable High Court. I am doing it.
All burden on the court.
All is burden of the court.
Therefore, yes.
They are keeping the right on the order of the court. So why officers will not, who are dealing with the files, will not come and disclose their stand in writing before the court?
Let them
please
disclose their
consider this.
stand in the order which they will be passing on my representation. That will also
Please consider this. But whether, Millard, on a statutory due, can there be any reconsideration?
Let them do it. I am ready to pay. I have to. That is my representation. I am ready to pay. That is
Please
also
consider
there.
this. And over and above, Millard, this page 313. After that, Millard, whatever your lordship feels, we'll definitely.
Let them say that we cannot reduce it. That's
So, Mr. Dotti, come, at least you come with a report or an application for recalling.
That can be done. That can be. Then kindly adjourn it without saying anything. Please keep it next Friday. In the meantime, I'll advise my clients.
Yes.
Whatever to do.
Yes. Either you find that part of the year is to be recalled.
That part is concerned. This is my lord's prerogative.
Right.
I think my lord is little hurt of this statement and withdrawing. So far as the litigant is concerned, my lord, if this order is passed, according to me, it is a very innocuous prayer. My representation is there. Let them consider it. Say, no, I statutory due cannot reduce. I am ready to pay. It is not that I am not ready to pay. Let them consider this and let us come back.
On that date, Mr. Roy submitted that resolution plan was filed in insolvency proceedings. So you just show that this plan permitted you to run or to take over the management. Initially, this impression was given to the court that a group of individuals has taken over the management of the company.
My company.
Initially, maybe I am wrong. I have not entered into the merit.
Not discuss on the matter.
And I was stated that insolvency proceedings is going on before NCLT such and such. Now, Mr. Roy says everything concluded. Everything concluded. So there was most probably a resolution plan. So resolution plan permitted you to take over the management of the company.
On that basis only I am there. Page 74. On the basis of that resolution, I am there.
Yes, on that date, you come with that. Court will only want to ascertain the resolution plan permitted you, and the insolvency resolutions professional also accepted the such and such.
This page was placed on the earlier when I appeared.
Okay, on that.
I have not gone into the marriage. My lord is also not. So far as this management can be made.
You have a right to insist on. Yes. You have a right to insist them on consideration your prayer. So before that court just ascertain, you have a right to make a prayer. You have a right. Okay, Mr. Bose, you are also, both of you are senior. We have learned from you. I am to say that there is an inaction on the part of the post trust in considering your repentant. The post trust cannot sit tight over the matter for an indefinite period. That inaction. So before that, you have a right to present the repentation before them. You satisfied? You satisfied on that date. So you come with the resolution plan on that date. And Mr. Dotto, you come with at least something in the writing. A report in the form of affidavit.
But I'll try to assist you, Lordship.
Okay. So, had the learned advocate appearing for the respective party leaves the matter for further consideration. Both of you agree to a date on that date. Court will accommodate. Next Friday, করা যাবে? Next Friday দেওয়া যাবে?
We can have some problem on Friday, Thursday, if this slot is available.
You are in so hurry.
Yes, madam. I'm running a factory without anything.
Friday week করুন।
Friday we 25.
Thursday, madam.
Okay, 25th.
Thursday is problem. We need lots of.
No, Mr. Dotto is in. No, we are creating pressure.
That I always do.
That is his habit. That is his habit.
You know that also.
So when next Friday or Friday week?
Friday.
Place the matter in the list. In the daily supplementary list on Atho. Place the matter. The list on Atho such and such at the fairly top of the daily supplementary list. Fairly top at the fairly top of the daily supplementary list. Dated 25th. Such and such. So I am not passing any order.
But could it be at 12?
if the business of the court permits.
তাহলে placed on এত to be taken at 12 m. ঠিক আছে?
My lord, one extreme indulgence, but one civil division has been assigned to a lordship's court, my lord. It will be listed as to be mentioned on Monday. I'm mentioning upon notice. Lordship, kindly seize this. এটা একটু দিন না, এটা একটু দিন না, এটা একটু দিন না, দাদা, এটা একটু দিন না।
Which is your other side?
Well, I'm mentioning upon notice. To be mentioned on Monday. একটু kindly দিন।
Why to be mentioned on Monday?
This matter has been assigned to a lordship. Lordship, kindly takes that. Lordship, kindly takes that.
Why to be mentioned? Assigned matter will be
Yes, yes,
taken.
assigned matter.
Assigned matter will be taken.
My lord.
That does not mean that immediately keeping all the matter
Not that,
aside.
not that. But I'm suffering an order of injunction.
Assignment order.
Lordship,
What is the assignment order?
kindly-
If there is any such
My lord, kindly see page 3, my lord, page 3, third page. This is the order, my lord.
no, yeah, that Chief Justice
Yes, Lordship, kindly takes
instructed
that. Yes,
this court
yes.
that for all the
No,
matter,
not that.
now only take your matter immediately.
Takes up the
Well,
last page. My last page.
you saw that.
My kindly takes up the last
So
page.
why are you here?
But any day, my lord. Any day.
Why?
But
What is that?
suffering an order of injunction. That is why. Order of injunction.
That is another aspect of the matter.
That is why my
You are fixing under which
no. I
heading
was
it will
praying.
be placed.
I was humbly praying. I was humbly.
Okay, to be mentioned only for release from my list.
No, Lordship, kindly not do that. Lordship, kindly not do that.
No, so you are directing.
No. But any day, my
Let it placed under the heading to be
any
mentioned.
day subject to my.
You say that there is an urgency, immediate intervention of this court
Yes,
is
Lordship,
required.
kindly.
That order.
That is my prayer. That
Under which heading shall be
Lordship,
placed,
that your
kindly leave this portion for the court.
my lord, my
Eh?
Lordship.
Now everything, we know we have lost some of our jurisdiction.
But any day, but any,
Some of our jurisdiction.
but any day.
Eh? No, assignment জেনে হবে সেদিন দিয়ে সব assign.
But any day, my lord, any day.
Oh, yeah. Who is the other side? So I am extending the interim order. Yeah.
এই দেখো স্যার পড়ে গেছিল।
Subsequently, it has been extended in their presence.
Item number?
But
2020.
Oh, acha.
Last occasion, my lord, on 20th.
As a hard the learned advocate appearing for the respective parties to establish the matter for further consideration. July? Huh?
Second, first miscellaneous, go back to the my lord, before justice. Sir.
Oh, acha.
Period.
This is my lord, suppression of material facts. They are
No,
10 years.
this court has not jurisdiction. Oh, acha. Oh, acha. So how the Satan Saj? Acha, yeah. Acha, leaves the matter for further consideration. Acha, before the regular bench on 7th August.
Why segment house? This is only this will appear in the regular bench only for today. This is appearing in the lordship. Yes.
Okay, some breathing time. Okay, yeah. Raju Potari. Acha, on 23rd July.
No. My lord, this is, my lord, injunction order was obtained without serving notice, and since
So what do you want?
my lord, I am opposing the injunction. I'm opposing the injunction
Kindly see.
because a stranger cannot claim injunction in my property.
Well, kindly see, my lord, 20th.
Okay, wrongly or rightly an injunction order has been passed.
And subsequently, it is.
You have not challenged that injunction order
Yes,
before
I have challenged. and
before the
it-
higher forum.
application for vacating of injunction order is also pending.
So let the application be disposed of, decided.
Yes, that will be decided.
So without taking decision on that application, the order will be
But that-
vacated.
Only your lordship, when the matter is only for today, they have come for the last day of your lordship, this when the matter is being taken up from the other bench. But on this day, he is claiming that interim order should be extended. Why they have not come earlier? Well, this is the problem. Your lordship's jurisdiction for this case only for today. And next it will go to the other bench.
Still the state is enjoying.
Yes, he is enjoying.
So he has a liberty to come on the last day. You give answer.
Only then
You give answer.
only injunction for the.
And one person has a right to paper in appeal and application on the last date.
Yes, my lord.
When the
That is
period
my-
of limitation will expire.
Then my
You
lord,
cannot force that why you have not filed earlier.
I cannot.
He
force
has
anybody.
every right
I cannot.
to
force.
make.
I am the appellant
last
here. I am the appellant here. I have
Wow.
not read the injunction.
1322 so একটা কবে দেবেন ওকেও তো একটা দিতে হবে নাহলে ও বললো হবে না
Only for one day.
22 on 22nd July interim order
my lord,
passed earlier in this matter is extended until the end of July or until further order, whichever is
This will be
My lord,
extended.
item number 21 was
Danger is going to
item number
disturb me in my
21
property.
was also an application for extension of interim order. Although I have served, my learned friend for the other side was there.
When the interim order will
My lord,
expire.
interim order had expired on 30th.
So it
I
is
had-
to be reinstated.
Yes, my lord, I had filed the application within.
Okay, so
He was there, but take his up.
it cannot be stated in this way.
No, I am not requesting your lordship for that. my lord.
Okay, it would be taken on Monday.
Grateful, sir.
Monday.
Oh, under what heading your matter was? Motion. Okay, returnable motion, it will come under returnable motion.
Before writing item number 23, I'm
Now it is the, no, it's not the time.
আরে আজকে বসবেন না তো বেঞ্চ আছে।
Today I have a different bench, I have a division bench. Okay.
So very great.